For judgment, item number 1, OJC 12957 of 2000.
We have dismissed the writ petition with a cost of rupees 50,000.
I agree.
Item number 2, WPC 1365 of 2022.
Dismissed.
I agree.
Item number 2, WPC 1365 of 2022. Item number 3, WA 2401 of 2023.
Dismissed.
I agree.
Item number 2, WPC 1365 of 2022. Item number 3, WA 2401 of 2023.
Judgment. Now on 24, before the cyclone, the notice of reporting was issued by the OJE as well as the authorities, on which they insisted on production with certified caste certificate. And by today, 5 p.m. itself, if I do not produce, they will throw my seat to the stray or spot round, my lord. So I will be unseated. My ad may be taken up, my lord.
Who is
Judgment. Now on 24, before the cyclone, the notice of reporting was issued by the OJE as well as the authorities, on which they insisted on production with certified caste certificate. I will serve a copy. By today, 5 p.m. itself, if I do not produce, they will throw my seat to the stray or spot round, my lord. So I will be unseated. My ad may be taken up, my lord.
Judgment.
Now on 24, before the cyclone, the notice of reporting was issued by the OJE as well as the authorities, on which they insisted on production with certified caste certificate. I will serve a copy. By today, 5 p.m. itself, if I do not produce, they will throw my seat to the stray or spot round, my lord. So I will be unseated. My ad may be taken up, my lord. Now on 24, before the cyclone, the notice of reporting was issued by the OJE as well as the authorities, on which they insisted on
Please inform Mr.
May I, with the lordship's
throw my seat to the stray or spot round, my lord. So I will be unseated. My ad may be taken up, my lord. Now on 24, before the cyclone, the notice of reporting was issued by the OJE as well as the authorities, on which they insisted on
I want minors to file the correct address. May I, with the lordship's
throw my seat to the stray or spot round, my lord. So I will be unseated. My ad may be taken up, my lord. Now on 24, before the cyclone, the notice of reporting was issued by the OJE as well as the authorities, on which they insisted on
I want minors to file the correct address. May I, with the lordship's
throw my seat to the stray or spot round, my lord. So I will be unseated. My ad may be taken up, my lord. Now on 24, before the cyclone, the notice of reporting was issued by the OJE as well as the authorities, on which they insisted on
I want minors to file the correct address. May I, with the lordship's
throw my seat to the stray or spot round, my lord. So I will be unseated. My ad may be taken up, my lord. Now on 24, before the cyclone, the notice of reporting was issued by the OJE as well as the authorities, on which they insisted on
I want minors to file the correct address. May I, with the lordship's
throw my seat to the stay or spot round. So I'll be unseated. Taken up my notice. Now on before the cyclone, the notice reporting was issued by the OJE as well as the authorities, on which they insisted on.
To file the correct address, may I also lodge?
Stay or spot round. So I'll be unseated. Taken up my notice. Now on before the cyclone, the notice reporting was issued by the OJE as well as the authorities, on which they insisted on.
To file the correct address, may I also lodge?
When did you give the mention slip?
So I'll be unseated. Taken up my notice. Now on before the cyclone, the notice reporting was issued by the OJE as well as the authorities, on which they insisted on.
To file the correct address, may I also lodge?
When did you give the mention slip?
So I'll be unseated. Taken up my notice. Now on before the cyclone, the notice reporting was issued by the OJE as well as the authorities, on which they insisted on.
To file the correct address, may I also lodge?
When did you give the mention slip?
So I'll be unseated. Taken up my notice. Now on before the cyclone, the notice reporting was issued by the OJE as well as the authorities, on which they insisted on.
To file the correct address, may I also lodge?
When did you give the mention slip?
So I'll be unseated. Taken up my notice. Now on before the cyclone, the notice reporting was issued by the OJE as well as the authorities, on which they insisted on.
To file the correct address, may I also lodge?
When did you give the mention slip?
So I'll be unseated. Taken up my notice. Now on before the cyclone, the notice reporting was issued by the OJE as well as the authorities, on which they insisted on.
To file the correct address, may I also lodge?
When did you give the mention slip?
So I'll be unseated. Taken up my notice. Now on before the cyclone, the notice reporting was issued by the OJE as well as the authorities, on which they insisted on.
To file the correct address, may I
Taken up my notice. Now on before the cyclone, the notice reporting was issued by the OJE.
When had you appeared in the DT examination of सेसु? कब वो एग्जामिनेशन कब था जिसका पेपर आप मांग रहे हैं?
April 2008.
2008.
Yes.
इन दिस रिट अपील आप यू आर आस्किंग कि वो पेपर मंगवा जाए और उसके बाद हियरिंग कंक्लूड हो.
Yes, sir.
अच्छा ठीक है.
No, that submitted on the last date, all the judgments, man, in all the cases, everything in detail, it was discussed and dismissed, man. Read petition, then review petition, it was dismissed, then read appeal, then again, in all cases.
देख लेना नोट चाहिए. His written note is there. Your written note. Have you filed a written note or just copies of the judgments?
Copies of the judgments. If your lordship permits, I'll also.
No. If you file it late, then again we'll forget. Yeah, those are there.
All the judgments I have submitted, man, also. Last date.
Yes. All right. ठीक है. Heard Mr. Chakradhar Sahu, learned petition appellant appearing in person, and Mr. Pranay Mahanti, learned counsel appearing on behalf of the respondent. Hearing is concluded. Order is reserved. Order / judgment is reserved. नेक्स्ट डेट नहीं तो वो जजमेंट पे आएगा. आप लिस्ट चेक कर लीजिए. ठीक है.
And the judgment shall be communicated to you. If you are not, आप यहाँ पे नहीं है तो जजमेंट आपके पोस्टल एड्रेस पे चला जाएगा. ठीक है, खबर हो जाएगी. आप
2 सप्ताह के बाद आप चेक कीजिए. ठीक है.
Item 15.
Item 15, there is a delay of 95 days. And the
matter that has been decided relying on judgment in that Satyavrat Naik case. In that Satyavrat Naik case, that order is reserved by my lords. That lords may see
Huh.
that page 59,
What is Satyavrat Nayak?
that is regarding that Hindi teacher's case, that educational qualification.
42 years or 42 years, I think. Age relaxation, 42 years.
No, this is not age relaxation. This is regarding that educational qualification that they don't have that. My lord, sir, that order is
Your
reserved.
synopsis says it is that upper age limit. Check. Am I mistaken? Anyway, let us issue notice. Disposed of on the first day.
Yes, ma'am. That Satyavrat Naik case that has been heard by my lords, and that order is reserved. If that will govern this case.
Mr. Mr. M.K. Funtia, learned additional government advocate, is in IA 2994 of 2023 undertakes to file the certified copy of the impugned order within 2 weeks.
Ma'am.
Within 2 weeks, the IA is accordingly disposed. IA is disposed of. In condemnation or delay, issue notice.
Ma'am.
4 weeks.
Yes.
4 weeks, list 6 weeks. No, returnable within 4 weeks, list after 6 weeks. Date.
11th December.
Okay.
Item 16.
Somebody has appeared.
I appeared. I have already served copy.
Served copy on him also and all right, because you had not filed
Because in the
requisites.
contempt application, my lord directed to serve the writ of appeal. Has appeared. Is here in.
Mr. Kora, have you received a copy of the IA for condemnation of delay?
Writ of appeal copy has been served.
IA for condemnation.
Invitation petition function, I am here to do.
Please serve a copy. Because limitation, you are supposed to file requisites, you have not filed requisites.
Already given, but I am again serving.
All right. Mr. PC Kaur, learned counsel has appeared, learned counsel has appeared on behalf of all the respondents or on behalf of respondent number 1. Copy of the IA for condemnation of delay is served on him in court. He prays for 10 days time to file an objection. This is the case on 19th. List the case on
20th.
Wednesday. List the case on 20/11/2024. Mr. A.T. Swain, learned counsel, submits that copy of the appeal memo has also been served on Mr. Kaur. You also, have you served a copy on the state? Well, that is also the noting.
Already served.
He also submits that the IA for condemnation of delay has been, copy of the IA for condemnation of delay has been served on the learned state counsel, appearing on behalf of respondent number 2.
Item 17.
Obliged.
So item number 17 and 18 has become infructuous, Your Lordship, as they have issued letters yesterday in the evening conducting the inspection as well.
My lord, already we have issued notification for inspection. Those 3 institutions, we have already given them notification for inspection. Date has been fixed. And for my lord's information, the INC has extended the admission up to 30th of November. Yesterday only they have mentioned.
For the nursing?
Yes,
Yes.
all nursing courses.
IA
have you arranged that
14301 of
party?
2024.
It's an occasion to celebrate.
So they have to celebrate.
Why?
My lord's order was there to give us all.
Anybody who takes certified copies should celebrate.
No, my lord, 2 matters are there. three matters are there, nine, on serial number 9.
All right.
That
Yes.
matter, I will place the order and that may be modified to that extent because that has been extended.
And what about those pharmacy cases?
Farmers 30th of November also.
That is extended or earlier only it was there?
It was, no, it was extended
By whom?
by Pharmacy Council, by virtue of the Supreme Court direction.
So that those two cases were there yesterday, you did not tell us.
No, that was pharmacy institution, only one was there.
Two were there.
Because my lord used this.
One D pharma and one B pharma.
That's what, because.
You missed. We had to correct at 8
Yes,
p.m.
I am sorry.
Anyway, those have been disposed of.
Ah.
We didn't know that time is extended, so that also that 3 days, 7 days has been given.
Yes, my lord will pass these two cases. And
No, if you give, we'll give. But this IAs have become the infractures we are disposing of.
and also he is not telling. Date has to correct in the.
7/11/2024.
It
It
was
has
7/10. Order.
No, he's saying it has become infractures because you have issued a letter. So why
We
should
have
we
issued-
extend the date?
Item 17.
No, his miscase is for that.
17. No, he says it has become infractions.
That is then I have no.
Right?
Your Lordship.
Whose letter? He has received a letter. IA 1/4. Sorry, what is this IA? Item IA 14301.
Your Lordship.
Yes.
1447.
Oh, sorry, I'm looking at the later matter. Yes, sorry. IA 14475 of 2024. This IA has been filed. Hey, Baba. Oh, this were you stating about that minister has allowed in other cases that you were stating yesterday. So after you filed the IA, they extended. This IA has been filed for modification of the order dated 23/10/2024 to consider the case of the petitioner in parity with the case of Maheshwari GNM Training School and Jaipur College of Nursing, Jaipur. Mr. Subhankar Raut, learned counsel for the petitioner, submits that he doesn't want to press this IA as the who has extended. You have the order with you?
Your Lordship, DMET has extended. DMET has issued a letter yesterday in the evening. My learned senior has a copy of that.
69 institutions we have already given. His serial number is.
As the DMET has issued a letter in respect of the petitioner's institution as well as 68 other institution
69.
Total 69.
Total 68.
Total 68. So how
No,
69?
69 minors has told one.
Petitioner's institution as well as 68 other institutions.
Yes, madam. Yes, madam. Netaji is 48. And Josoda is 69.
Asking them to submit documents for virtual inspection.
Inspection,
No date
yes.
has been fixed.
Date has been fixed.
When?
That is 5th of November for Netaji.
Another letter
Last column.
fixing
Yes.
5/11/2024 for inspection.
And
In rest-
Josoda too is also
Same.
6th,
Your Lordship, same.
6th of 11.
Next time we'll fix for them.
Yes.
Fix. All.
In item 16, Your Lordship, I am appearing on behalf of Mr. Rupesh Kumar Kanungo.
Okay. All right.
Item 17, 18.
Yes, yes. Mr. Subhankar Raut on behalf of Mr. Rupesh Kumar Kanungo in item 17. 18 he is appearing. So same. The IAs are the same.
Your Lordship.
All right.
16, I am appearing on behalf of Mr. Rupesh Kumar Kanungo. 17 and 18 is same.
16 you are not appearing. In 17 you are appearing for
sorry.
Mr. Kanungo.
17, 18.
Madam is there. Madam could have. Why didn't you allow Madam to make the submission? Yes. What is the date for 19?
Item 19.
Then 6/6/11.
That also 6/11. Fixing 6/11 for inspection. First one is 5, the second two are 6/11.
Item 18 and 19.
I is put a minute. I is disposed of as infructuous. Huh, kon?
Typo error is
Oh.
instead of 7/11.
That's why I mentioned. That's why I mentioned.
Registry has pointed out that the date of the order has been inadvertently. No, but modification was for date.
Yes.
Has been typed as 7/11/2024 in place of 7/10/2024. The order is corrected. The corrected order we uploaded in the website.
Both the matters.
Yes, yes.
Yes.
Orders not flow. Specially urgent matter, item number 1.
In item number 1, losses right, last order was pleased to direct me to file an affidavit so far as the developments in regard to the acquisition of land of the petitioners. Yesterday, the officers had come. In fact, on 17/10, the government has already instructed the collector to proceed with that proceeding and comply with lordship's order. The collector who has done recently, he has prayed for some time. He says that he is new to this, so 2 weeks time when he have prayed, lordship may grant him to issue the lord's process and other things.
Lord, Lord, after Lordship's order in 18/4, already 7 months have been passed and 4 adjournments already.
See, you are also at fault. Lord, we are just.
But after 40 years, they approach your lordship, and lordship, we are pleased to direct them to pay compensation.
No, that is not true exactly. Lord, we have approached earlier, not up.
As requested by Land AGA, to list this matter on 2 weeks.
Yes, ma'am.
Item number 2.
Thursday.
14th.
As the first item, because Lordship has directed
Yes,
on
yes,
last
yes.
3 occasions. Obliged.
Item 2.
This case, the judgment sought to be challenged. The present appeal has already been set aside by this honorable court in a judgment.
Your
In case of that junior teacher schematic.
Your Lordship on 27/8/2024 has passed orders, my lord, in similar cases.
Here there
So
was
that's
only delay of 15 days.
Lordship, basing on the judgment of Jaya Marathi case, my lord, your Lordship on 27/8/2024 has disposed of an identical matter, my lord.
That order you have given.
Yes, my lord.
No, but now this order was passed on 27/8/2024.
My lord.
And this judgment was delivered on, and same judgment.
Yes, my lord.
Same judgment.
Same judgment.
Same, then based on
Already.
accordingly this order can be passed.
Here there was only delay of 15 days. That is to be controlled. 15 days delay.
My lord.
In
Not object.
this, what is the delay?
15 days.
Here also.
Here also.
Because earlier goes also 15 days.
Because these read appeals were filed little bit late, 15 days delay. So
15
challenging the
days.
common judgment.
15 days is nothing for you. No, because this also is 15 days, that's why I asked.
Yes.
Item number 3. Number 3, my lord. The order dated 6/9/2024. At page 50 under challenge. And subsequently, I filed an application for recall. That was also rejected with or some order passed against me. Here I am the opinion 2 in the writ petition. The writ petition was filed by the.
Let us see the order.
Yes, ma'am. Let's count page 15.
Really.
Yes, you got it?
Yes.
Yes.
पढ़े
Last para. In filing the
Rocky
requisition, the petitioner being the auction purchaser of the disputed property in question has sought for a direction from this court to the opinion of one bank authority for handing over the vacant position of the disputed property in question to her. Apart from the above prayer, the petitioner has sought for a direction from this court to the opposite party bank authority for returning the entire amount deposited by her along with interest if they fail to hand over the vacant position of the disputed property in question to her. And senior counsel
What is
appeal on
wrong in
behalf
the
of-
order?
My lord,
What is wrong in the order?
my lord, here what happened? Surface case at my instance is pending before the DRT.
Then
Now, during pendency of the surface case, the one CRLMP was, the property was auctioned. And the bank has auctioned the property, but no physical possession was delivered to the auction purchaser. Now I am in possession. At this juncture, he filed an FIR against me. And your ship come to page 22.
Mr. Counsel,
My lord.
it seems that you have abused the process by filing this writ application.
No, I am not filed.
Huh?
I am the opinion. I am the opposite party.
Who's
No
the-
notice was issued to me.
The-
I am the opposite party.
Yes.
No notice
So
was
what's
issued to me
wrong?
by passing this order. And by passing this order, this honorable court directed me to vacate the suit property.
But the collector heard you.
No. That was over. No possession was given. I still am in possession. Surface case is pending.
The surface case may be
Yes.
pending.
And your ship come to page 22. The auction purchaser filed another CRLMP.
And
That
what
was-
happened in that case? This order was passed on 6/9/2024. And essay was directed to be disposed of within 1 month.
Yes, ma'am.
So what happened?
That is, yesterday that matter was there, but no order has yet been passed. Fact remains, my lord. Para 7, I am agreed by para 7. Para 7, page 17. This honorable court directed me to vacate the suit premises. Here, fact remains, this writ is not maintainable. Fact remains, earlier petition was rejected by this honorable court at page, your ship come to page 19.
No, but why will you not vacate the order, the premises?
Then I filed a recall application. After getting this order, I filed a recall application.
No,
That
but
was
why will
rejected
you
by the
not
Supreme-
vacate the premises?
But that's why I challenged before this one in this writ appeal, my lord.
What challenge?
That order is challenged in this writ appeal, my lord.
How can you occupy the
But
house?
still I'm in possession
It has been
and
occupied.
my case is pending for the DRT.
We will direct the DGP because this.
But here what happened, my lord? One thing. You see, I am placing one, just I am giving your one order. You see, come to page 22. Page 22.
22.
Page 22 of the writ appeal.
What for?
Here, this honorable
See,
court,
your house has been auction sold. How are you occupying the
my
house?
lord, the case is still sub judice of the DRT. The case is sub judice of the DRT
Let the,
at my instance, my lord.
just a minute, just a minute. I will ensure that you vacate.
What is the position of the case?
Position that is here my case was
In
for-
DRT, what is the position of the
here,
case?
that was not otherwise ready for hearing. But after getting this order, now DRT has fixed for orders. And that has not been passed.
Oh, yes,
It is posted for judgment today, Your Lordship.
Yesterday,
tomorrow.
yesterday. Your ship come to page 23. One line.
no,
my
no,
lord.
page
I am
20.
challenging
No,
veracity of
sorry,
the order,
sorry.
my lord.
Sorry.
Your ship come to page 23.
Await,
Sorry.
Mr. Moon, awaiting what is the judgment today, we are keeping the case to next week.
Until then, your ship must stay there.
But
You
not
already-
required. If judgment is delivered today, is it required?
My lord, one
Let's-
thing, my lord.
let's
Now
this
the
matter-
police is taking steps to
let's-
evict us from the premises.
Let's this matter on opening first day, no, fourth.
Fourth.
Retaining its position. Yes,
Item 4.
Kindly grant some time to file counter affidavit.
no requirement. Which matter? Fourth.
For my lord.
Mr. Naik has appeared on behalf of?
Yes, we are for respondent one, Your Lordship.
Mr. Naik,
I have also entered me.
yes. Sir, Nadaling, SK Sadangi, Learned Senior Counsel, along with Mr. A.K. Naik, have appeared on behalf of the respondent.
One.
Respondent one.
It's a time, counter.
But Lordship, in the present case, it can be tagged with the earlier matter next week. So that in that batch of case, they have filed counter. So it can be disposed of, Lordship, because the mining operation has been stopped due to technicality, Lordship. Though, Lordship, even in internal protection, though I have divided the entire amount as per Lordship's direction, due to technicality, because the department has been changed. Now the authority has been changed to revenue to mines department. Now this order has been issued by the mines officer, Lordship. So that's why this fresh writ application. And the Lordship can have given a certificate in other writ applications. Your Lordship issue notice and they have filed counter in connected cases. So it can be tagged with other matters. So can it be disposed of by next week, Lordship?
Yes.
The entire.
No, in fact, my lord, this is the subsequent year. Demand that is earlier notice was issued and we have filed counter. My lord,
That is what he's saying.
My lord.
Since you have filed counter affidavit in that case, let
My
it be
lord.
tagged together, both can be
my
taken.
lord.
How much time will you take to file counter affidavit?
In
No,
other
2 weeks,
cases,
2 weeks, my lord.
They have filed Lordship in other connected
But
cases.
see, in this case also they will file a counter affidavit.
Same case, Lordship.
No, either file or adopt. They have to
Lordship,
do
so
that.
My lord, 2 weeks, my lord. Within 2 weeks, we'll file counter.
This matter on 2 weeks so as to enable and AGA to seek instruction for filing instruction as to whether fresh counter affidavit shall be filed or the state shall adopt the counter affidavit already filed in WPC number.
Lordship, 18001 of 23. In first case, Lordship. First case 18001 of 2023. And in second case, 286. I give you a certificate, Lordship.
First case
First
is
case,
17936. In your certificate, you have given the case number to be
18001. That is case 4, Lordship.
8611 of 2023. That means another case you have filed.
Two cases, Lordship.
Look at your certificate
cases,
in
my
this
lord.
case.
4 and 5, 2 cases.
I have two cases, Lordship.
In 17936,
Lordship.
you in your certificate you have given 298611.
28611, my lord.
11.
No, certificate, Lordship, given 18001, Lordship. Page 4.
And item 4.
Four type.
You are saying
Oh,
for us
sorry, Lordship. Yes, Lordship.
28611.
6, Lordship. 28611.
28611 of 2023.
23.
23.
And what is that 17604 of
What
2013?
is dispute?
That means this dispute is pending since 10 years.
Lordship. No, not 10 years, Lordship.
Okay, 11 years. You yourself have given that reference.
A typographical error, right?
Type, Lordship, that is, sorry, Lordship, that is 2-3, Lordship, 1-3, yes, Lordship.
On 2 weeks along with WPC number so as to 3.
Or creation. 17614 of 2020.
23, sorry, 20, sorry. Lordship.
Typographical.
614 of 2023. 3 cases. This one and 2 other.
Item 5.
If,
No,
if
5 is same, my lord.
if the state decides to file a fresh counter affidavit, in the present case, it shall be required to do it within, do it by the next date. Yes.
In second case, Lordship, 18001 only, Lordship.
Same case.
Same, Lordship. That is along with 18001.
Correct.
Of 2023.
Item number 6.
Lordship.
18001.
Slightly. The petition land has been acquired by virtue of the notification or annexed B.
Acquired.
Petition land has been acquired.
Then
At page 18. Page 20.
Then what do you want?
Enhancement of compensation amount. By
Enhancement of
page
compensation, then why have you come here?
But prior to that, petitioner has purchased the land since 2013.
For enhancement, why have you come here? The acquired acquisition has been made under which provision? The land has been acquired under which provision of law?
Yeah,
Section 3.
assignment.
3A.
Yeah, the assignment.
16, 64, 16, 64. Why repetition? Why he should have approached for enhancement?
At page 21. At this level of service, there is different. And the question is, we will check on.
Compensation, no, your land has been acquired.
Yes, ma'am.
I leave it here.
Why the matter has been listed before us? No?
By virtue of
Yes, sir.
Okay, okay. That's, that I will. So you-
Yes.
Malad, at page 18, where issue shows that land has been purchased at the rate of 13,56,000. And
Sir, Counsel,
land
how your writ petition can be maintained? There is no provision under the act.
we have ventilated or given us before the authorities. Before the authority, land acquisition authority, they have not considered. That's why you are filing the case.
There are no act and resolution.
But the provision is there. Forum is there for you to ask for enhancement.
18.3, that is
Huh?
18.3 under the act.
Why didn't you go there?
No, we have gone to, and the order is annexed here with me. Madam.
Order is where?
Yes, madam.
National Highways Act ಅದಲ್ಲ? But a National Highways Act also. This is like the- You have the book with you, National Highway Act?
Yes, madam.
Do you have the National Highway Act with you?
No, ma'am.
Then how are you arguing the case? You can come with that.
You have to examine it. And you want us to read the book, read the act.
You come with the act. Because as per that notification, Tahsildar,
I'm not doing that.
you bring it, you read it and then you address.
Yes, where is the provision?
18.3 of 18.3 of land acquisition act.
Where?
Your land was acquired under which provision of law?
Right to.
All right, we will hear you on, as requested on behalf of the petitioner, is this matter on? Please examine case, madam.
Yes, Your Lordship.
On.
You have a copy of the petition? Yes.
Item 7.
You are Mr. Boysak. All right. You have the copy of the Land Acquisition Act you have? Bring both. Not that, you that right to whatever, right to fair compensation.
May I please, Lords? Is the case, is the case, my lord, the petitioner allotted a road work, my lord, and he has executed, my lord, out of 3 crores, 2 crores, 90 lakhs, my lord. And the 2022 is the 21 is the date of completion, my lord. Part of that land they have not acquired. There is a document we annex. I file a application to the closure application before the authority. They have not taken any decision. As per the agreement clause, the decision of superintending engineer is final. But what time he has been, it has not been specified. That is, my lord, my grievance, your lordship, they annexure, my lord, 3, my lord, 23 May 2022 up to 26 June 2024. The executive engineer several letter written to the BDA authority to remove encroachment, my lord. Lord, so they have failed to, my lord, to provide the land. So I file application to close my contract.
I'll obtain instruction, but so as document shows we have written it.
Document shows?
We have written to the authorities to give him lots of vacant possession so that he can proceed with the work. So I will obtain instruction what it is.
3 weeks.
No.
3 weeks time is allowed for the issue notice, separate notice. State को करना.
Obliged.
3 weeks.
Item 8. Grant some time to file counter affidavit mail.
My lords, this is that matter, my lords, where it is relating to the sand mining, where on one hand, the mining officer misinterpreted the judgment of this honorable court by saying that 7 to 9 p.m. 7 a.m. to 9 p.m. you're restricted from
So
transferring.
why are you not filing affidavit? Earlier also you were directed to file counter affidavit, no?
My lord, on 310, you are also directed to file counter affidavit.
Yes.
I have written them and I have requested to grant.
October is over.
My lord.
310 we directed.
My lord.
October is, the month of October is over. So if we grant you further time, you may file an affidavit after 1 month.
No, on 310 notice was issued, my lord. You are also directed to file counter affidavit, my lord.
Yes.
I have already informed them, my lord. They have requested to grant your lordship to grant some time.
Who has requested?
My lord, the mining officer.
When did he request?
No, I have already telephoned him, my lord.
See, Mr. Counsel, do you want us to pass an order that if we direct filing of a counter affidavit within a particular period, the opposite parties, the state respondents are under obligation. That is a judicial order.
My lord.
They cannot take the order so lightly. Should we pass an order?
No, my lord.
And initiate contempt proceeding if the affidavits are not filed? Your mining officer does not have time. Why do you take the judicial order so lightly?
My lord, sir, this is a matter where it was argued.
Was there any direction issued for filing counter affidavit?
This was issued.
The court is unnecessarily.
Amendment to application was allowed. Consolidated petition was filed. So
Next time is allowed for the
Only difficulty, my lords, your lordships were
state to file
alive
counter
to,
affidavit. List this matter on.
your lordship were alive to the fact that the period will be
Next.
expiring in December.
yes, but you yourself filed an amendment and delayed.
Yes,
matters.
no,
It is all right.
your lordship will
So
recollect.
we'll grant them
Panchayat Raj
short
department
period.
was added, my lord.
Yes, we'll grant
Your
them a
lordship
short period.
would recollect that this is relating to that judgment which was misinterpreted. And
All
your
it
lordship
is.
were of the view that the Panchayati Raj department and the
We
revenue
will
and
still let
disaster.
them file affidavit.
Item 9.
My lord. Obliged.
We will call this matter in.
Yes,
Your lordship is keeping it to.
4 weeks.
Item 9.
Obliged.
Now, item 9 is that nursing matter, where minors are given direction for inspection. And my information is already this institution has been given notice for inspection, that is fixed 2nd of November. Inspection to be conducted on 2nd of November.
Yes.
Well, the third item in the item number 9 is the third item, Melos. Read petition number 26415, Melos.
He has not given copy to me for pharmacy.
Have you given your table today?
Yes,
So this is
yes, that table I have given.
included in your table. Kind of table. Tejan, the table. I think table we have not taken because first
I am
three-
giving another, I am giving another one.
first three cases table was not required.
Table is not, I have not given today table.
So
Today I have not given table because three cases,
only three cases.
yes, three cases only.
So what is this?
My case.
First one is already, we have given inspection date.
Also, it is infructuous.
Yes, ma'am.
You sorry, you gave that list. Here, this. You're given this list.
That
That
list
has
I-
a table.
Yes.
Yes. So serial number? Is it there in the list?
Radhakant is,
Sai
serial-
Academy, Sai Medical.
I am Academy is serial number 41.
41. Sai Medical College Nursing. All right, 41.
Date is fixed to 5th of November.
This application. So then today, how many matters are there?
Only three.
Only three. All right.
This is only one.
This application has been filed. NOC for the year 24. For a direction to the opposite parties to allow in online inspection of the institute for renewal of NOC for the academic session 2024-25 for which course?
Yes, nursing.
For the BSc nursing course. Full stop.
I have already written in that column.
Mr. R.C. Mahanti, learned counsel appearing on behalf of the DMAT submits that letter has already been issued to the petitioner institution fixing 5/11/2024 for online inspection. Full stop. In view of the above submission, the application is has been rendered infructuous and is disposed of as such.
The second one is 11, serial number 11,
The same order.
same order.
Only
And the
date, let us see.
Date is only 2nd of November.
The date is 2nd of November. That is 11.
Yes, madam. 2nd of,
So this is WPC. Yes.
26173.
26173. 26173. All right.
Radhakant College of Nursing.
So this is what again BSc nursing?
Yes, the BSc nursing.
BSc.
But date has been fixed to 2nd.
No, that I'm just
BSc nursing.
calling out because that will be on BSc nursing.
BSc nursing.
All right. Third one.
Third one is
Third
the
one is
pharmacy college,
pharmacy.
my lords.
Have given me copy and pharmacy matters, my lords, have
30th.
adjourned to 11th of November.
All right.
Copy should be given to me.
So that means the pharmacy courses which were there yesterday, we should have adjourned to 11/11.
But I omitted this because
We are relying on you and then.
No, I'm sorry, my lord, because I am not, even if that is given also, no problem. Who will inspect and get this?
There's no problem. You don't have to issue order also. You are issuing on your own.
No,
So
my
there is
lord,
no
because
problem.
Due to this Ross and all that. I was
All right.
confused.
Mr. R.C. Mahanti, shall we issue notice? You've served, you received copy.
No copy has
I will serve within the course of the day, my lords.
Learner counsel, you are Mr.
N. Behuria, my lords.
Sorry?
Nityabrata Behuria, my lords. N. Behuria.
All right, Mr. N. Behuria, learned counsel submits that he shall serve a copy of the writ application on Mr. R.C. Mahanti, learned counsel appearing on behalf of the DMT by
Today, my lords.
in the course of the day. List on 11/11/2024 on which similar matters are listed.
Yes.
Counter, if any, may be filed in the meanwhile.
Much obliged.
Item number 10.
On behalf of Mr. Das Millard, and the similar matter, my lord has given interim order, my lords, regarding the matter relating to admission of ITC, private ITC, my lord. The bunch of matter has been heard, my lord.
Yes.
Give him order so that he can see whether that order is.
Or copy.
ଆପଣଙ୍କ କପିଟା ଦିଅନ୍ତୁ ଦେଖିଦେବେ. You only have one
Original copy,
original.
certified copy.
But are you not getting online certified copies? Yeah, what difficulty will we have?
30. We'll take it up along with item number 30. You make copies and serve.
None,
All right.
none.
One for two for the court, one for him.
Item is 11.
May I be the words? In this case, the petitioner has challenged inaction of the state government to implement inaction of the state government to implement 10% EWS quota
10%?
of EWS quota. Economic weaker section quota.
Under which provision of-
Economically weaker.
Yes,
Under
as
which-
per the amendment of 103rd Constitution of India, that is inserted Article 15 of the Constitution of India.
Slowly.
Yes, my submission that in
Where is
2019,
the constitution?
that is inserted after amendment of 103rd Constitution of India, that is incorporated in Article 15.
Please read it.
Any special provision for the advancement of any economical weaker
Mister, please read the provision.
that I am reading.
What is that?
Prohibition of discrimination on ground of religion, race, caste, sex, or place of birth. That is Article 15. But as per the amendment, 103rd Constitution of India.
Please read the provision because I have read.
Just I am allowed to.
Please read.
Yes. Any special provision
Yes.
for the advancement of any economical weaker section of citizen other than the classes mentioned in clauses 4 and 5, in so far as such special provision relates to their admission to educational institution, including private educational institution, whether aided or unaided by the state, other than the minority education institution referred to in clause 1 of Article 30, which in the case of reservation would be in addition to the existing reservation and subject to maximum of 10% of total seats in each category. Thereafter, for the purpose of the Article 16, economical
Just a minute. Which provision you are reading?
B, Article 15,
Yes.
B, Miller. 6B, clause 6B, Article B.
So you have not read 6 and you are reading B.
Yes, 6. Yes, sir.
Please read 6.
Yes. Nothing in this article or nothing in this article or subclause G of clause 1 of Article 19 or clause 2 of Article 29 shall prevent will.
So it is not that they are under obligation. They can do it. They may not do it.
It means my
So
lord,
the High Court will not issue direction.
my submission that when
Your submission may be your submission.
they have
Prevent means they have the authority. They can do it. There is no prohibition.
whenever
And you are seeking a mandamus from this court.
my submission that
What submission?
now only 39 seats have allowed the EWS, but instead of 10% as per the amendment of Constitution of India. But whereas the neighboring states, they are allowed 10% out of 85% of state quota mill. And in this case, what happened, Miller? When of
Neighboring state and neighboring countries, these submissions you are not required to make. See what provision is there in where you are living.
now when the central government is allowed 10% out of 15%, there should not be unjust in favor of the independence out of 80%.
All right. The
I'm
present writ application has been filed under Article 226 of the Constitution of India, seeking a direction to the opposite parties to allow the petitioners to take admission in MBBS course for the academic year 2024-25 by reserving 10% of seats out of 85% state quota in each government medical college, in accordance with the Government of India reservation policy. First off, this writ application cannot be entertained for two reasons. So firstly, the last date for admission to MBBS course for the academic session 2024-25 has already expired. First off,
Third round is over.
Huh?
Third round is over. Third round is over. Third round of selection is over.
Last date has not elapsed. That is what we are saying. Last date has gone.
last date has not. It is not over.
Third round is over.
What third round? They have.
Yes,
10
yes,
rounds.
third round is over. As per my knowledge is concerned, third round is over.
Last date on 5th of November. 5th of November.
5th of November. This writ petition cannot be, London Council appearing on behalf of the petitioners have vehemently relied on Article 15, bracketed 6, bracketed B of the Constitution of India in support of his submission, and has argued that the state of Orissa was under obligation to provide 10% quota for economically EWS candidates. First off, next, it is apparent on plain reading of Article 515 bracketed 6 of the Constitution of India that the same is an enabling clause which authorizes the state to make provisions, 6 bracketed B, make provision for advancement of any economically and weaker section of the citizens. First off, no mandamus is required to, this court is not required to issue any mandamus
I may take like, I'm allowed.
requiring the
Unless-
government, state government, to make provision for reservation in terms of Article 15
6.
of the Constitution of India. First off, it is the appropriate government to take a decision as to grant, as to provide for reservation or not. First off, this writ application is misconceived and is accordingly dismissed. Yes,
Item 12.
Our appearance may be noted for 1 and 2, my lord.
yes.
Item 12.
I'm appearing for 5.
Yeah, please, Lord Similar. In this case, the petitioner is filing this public interest litigation. Submitting grievance before the 12 minute. He has made grievance before the Chief Secretary of the State Government of Odisha that District Mineral Foundation for Trust Board fund has been irregularly exercised by the District Foundation Trust Board. Though the rules provide a particular act has to be done in a particular manner, that such rules has been taken and that has been ignored, that the authority proceeded haphazardly.
What is this PIL about?
PIL about the irregularity and mismanagement of the District Mineral Foundation Trust Board of Kendusar District. The rules I have annexed.
Fund of the trust board.
Trust board. The rules.
What are they doing?
The rules I have annexed page 75.
Yes.
Odisha District Mineral Foundation rules. Rules.
Mineral Foundation rules.
In mining districts, for the development.
Mineral Foundation.
Mineral Foundation.
District Mineral Foundation. All right, trust.
The mining operation carried in different districts for development of the inhabitants, the foundation trust has been created and the rules has been framed for regulating that foundation trust. Board has been constituted under the rule, and executive committee has also composed and composition was made on the rule. The power of the board to create sanction of the projects more than 10 crores. Rule 5, sub-rule E prescribed the grant of administrative
Where?
tax. Page
Where?
78, madam. The rules. Powers and functions of the board.
Yes.
The rule, sub-rule E says grant of administrative sanction of individual projects exceeding estimated cost of rupees 10 crores. When the project cost for developmental projects in the district more than 10 crores, the trust board has to sanction the approval. As per rule 6, sub-rule 2B, if the project cost is at page 79, madam.
So you are reading page 78.
78E, para rule 5E is the power of the board for giving administrative approval in respect of the project cost more than 10 crores.
Yes.
So far as the project less than 10 crores, the power vested with the executive committee.
Yes.
But what happened in the Kendusha District Trust Board, the more than 76 projects has been carried out without approval of the trust board. The value of the project is more than 10 crores. And on the basis of this rule, the Hyper Committee took decision at page 96, madam. In the 90s, the committee meeting dated 10th September 2019 at page 97, there was a direction to the District Mineral Foundation Trust. When a work has been executed, 30% initial amount has to be paid. During course of work, another 40% the project cost has to be paid. After completion of the project, the remaining 30% has to be paid. Page 97 kindly. Clause
Yes.
E.
Yes.
The DMF shall place funds in 3 installments, 30%, 40%, 30% of the total allocated amount over the project implementation period, subject to realization of the 75% utilization certificate of previous released amount. But this guideline has been ignored by the authority. At a stroke, entire amount has been released in favor of the executive agency without approval of the trust board, and the work has not been completed, no utilization certificate available in the office. Therefore, I have made grievance before the Chief Secretary for inquiry that has been received under Annexure 1, but till then no answer.
Yes.
Well, since I have obtained instruction in this matter, because
Obtain instruction. We are of the opinion that in the present petition in the nature of public interest litigation, issue of significant public interest has been involved as regards the manner of utilization of fund by the district mineral foundation trust, Kyonja. Stop. Who is the chairman?
Chairman, the collector.
Let the collector Kyonja, who is the chairman of the trust, file a detailed counter affidavit dealing with the averments made in the petition. Stop. The next, the collector will be required to inform this court as regards the stage of different welfare projects undertaken by the under at the cost of the fund provided by the trust. 4 weeks.
Item 13.
May I please, your lordships? My lord, this relates to the contract in which invoking clause for my lord treating my offer as a withdrawal of the offer. Now they're invoking the bank guarantee and consequently the EMD. And apart from that, 1 year debarment. That is the subject matter of your lordships. On 7/3/2024, the OP number 2, your lordship, Mr. Tripathi represents, Dr. Tripathi represents them. They floated a tender inviting tender, my lord, for drugs, bulk drug supply. Bulk drugs means your lordship, whoever stands first, L1 they say, supposing 10 rupees is accepted, 2 and 3 can take the some supply at the ratio of 50%, 30%, 20%. If they agree at the same rate that is allotted to L1. That is there in the tender condition. That is bulk drug supply, there is the policy. So my lord, it was opened on the technical, it was closed on 12/4. Technical bids were opened on 25/5. 25/5. And your lordship, the financial bid was opened on
So where is your withdrawal?
my lord?
Where is your withdrawal? Where is your withdrawal?
Yes, I am taking your lordship to that. The proceeding was circulated, your lordship, in the website. Page number.
Which communication of made
Annex-
by you has been treated to be withdrawal?
I am taking your lordship to that. Any communication? No, they say it is withdrawal. I say revision of price.
Let us see that.
Yes, lordship. May I take your lordship to page 13 first? Annex 2. My lord, the quoted rates were 0.75 per, your lordship would look at, there's a tabular form. The quoted rates were 0.75 per tablet plus GST, and second is 0.30 per tablet plus GST. Rates to be quoted were 7.50 and 3 rupees. Instead of this, somehow there was a mistake, typography mistake. We assure you this was an error, was unintentional. Request your support in this matter and hope that our corrected rates will be considered for further evaluation. On the basis of this,
So you had quoted 0.75.
0.75.
And later you realize that it ought to have been 7.50.
It should be 7.50. And the similar is the case in the next item, 0.30, it should have been 3.00. This was the mistake I had committed, so I sought rectification. I have not withdrawn my offer as yet anyway. They were free to reject my offer.
So what else is withdrawal?
My lord?
What else is withdrawal? You quote something and later you say that that was a mistake and actually
I have not withdrawn the offer that to himself. They could have settled it at that rate. I never said that I won't supply. I am taking your lordship to that. So my lord, page 14 annex 3 is the proceedings and it relates to my
you are
case.
ready to supply at even 0.75.
Yes, your lordship.
Then you should never be allowed. See, your rate varies from 0.75 to 7.5.
I am conscious of that, your lordship.
Yes. You should never be. No.
It is a mistake I have taken. My lord, I am facing debarment for 1 year. The fitness angle of it. Your lordship, not that I am a very person who can suffer, gets that much of profit, my lord. I am facing debarment. My entire income is out of government supplies.
See, you should never be allowed because your rate varies from 1 to 10.
No, my lord, it is a mistake type of.
No mistake, but you are ready. Had you stuck to your position that no, it was a mistake. 7.5 is the price which you intended to quote, then the matter would have been different. But you are saying that was a mistake. It should have been 7.5, and then you say that I am ready to supply for 0.75.
I'm not, I
So,
answered possibly too quick.
you are not
to
supplying
respond to your lordship
medicine.
query. Possibly I was too quick for
But
that.
you have accepted the offer for 75 paisa?
No, that they rejected. That's the background. That they, sorry, did not reject. They said this is withdrawal.
We shall
and
see, Mr. If the cost of a medicine is 7.5 according to you, which you are ready to supply at 0.75, then you are not supplying the medicine.
That's correct, your lordship.
You are supplying something else in the name of medicine.
Your lordship, may kindly bear with me. That is
So,
not what I meant to say.
use
that.
risk.
What I meant, your lordship, I have not withdrawn the offer.
That we will see.
That they have
That
treated
we
the
will
withdrawal.
see. We are in red jurisdiction, Mr. Sarangi. That we will see.
Your lordship, may take page 15.
You will see your everything, blacklisting, everything is justified.
No, this is the treated. Why I am taking your lordship, page 15, my lord.
Yes, yes.
Last paragraph. The technically qualified items, these are my two items, lords, such and were excluded from the price bid evaluation. The farm will be debarred, recognized for a period of 1 year from the date of bid opening will be forfeited. EMD will be forfeited as per the tender clause number such and such as per the presentation received to the farm with reference to letter dated 25/7/2024. That is the letter they are referring to. My humble submission with your lordship, as it was I pleaded before them, this is not a withdrawal. I requested for reconsideration. You could not have request. Request could not have been acceded to. You should have rejected. Instead of that, you are treating as a refusal and debarring me. That causes prejudice. So what I did is I'll take your lordship to the relevant clause of the contract, where my lord 6.7.7. That is at page 37.
Mr. Sarangi, we are unhappy with the stand which you have taken.
No, that is something I should have taken instruction and stated. That is not
No
there.
question of sex. Everything is there. So in black and white. We will decide it on that short point. Can decide it.
Page 37, your lords.
Yes. Whatever.
Today, your lordship will decide. But you seek for response.
Today?
Your lordship will decide it now.
You may.
Yes.
Right now, we may decide.
Yes, your lords. Page 37.
Yes.
That is the relevant clause. But that concession which I said also, that may not be recorded. That is not an instruction.
Yes.
Page 37, my lord.
Yes.
6.7.7 towards the middle. OSMCL may debar, recognize the bidder and EMD will be forfeited if a bidder 6.7.72 fails to furnish performance security. No, my lord, sorry, 6.7.72 withdraws bid after opening of the technical bid.
Yes.
Technical bid was admittedly obtained on 25/4. I gave this letter after receipt of after coming to know about the financial bid wanted to open. This mistake I noticed and accordingly I wrote that letter.
Yes.
Which I clarified later on. And this has been invoked saying that this is withdrawal, which I am questioning before my lords.
Yeah.
And this I have clarified in a impugned order is 63 at page 63, your lordship.
Yes.
Apart from stating what has happened, the farm was technically selected for the above two items. During the technical, I had succeeded as was submitting, my lord. During the tender process, the farm has requested to withdraw the above two each items due to wrong price quoted in the letter dated 25/7/2024 and email dated 26/7/2024. In view of the above, as per the tender clause 6.7.7 and 6.7.72, the bid document, the farm such and such, is hereby debarred for a period of 1 year for item number such and such. From the date of technical bid opening, that is 23/4/2024 to 22/4/2025, with forfeiture of EMD, and farms shall not be allowed to participate in the tender process of the state such and such for the above two items. On receipt of this on 24/10, I made a representation. And in the last line, I have stated, in that apart from the other mistakes that I have committed, I have stated, my lord, I have requested for reconsideration of my price. Because even if that is taken into account, that revised price was showing, my lord, 7.5 plus 3, then also it will be L1. And since it is a bulk supply, my case may be considered. Apart from that, Your Lordship, that also I pleaded in that even if this is taken into consideration, my revised price, that is still L1, I'll be L1. And my lord, lastly, we request to place order on us at quoted for which we shall comply all the formalities. And we have also stated that we have not withdrawn the offer. This being the situation, Your Lordship, I am before my lords for direction to reconsider the entire facts.
Dismissed. Yes. Next.
For admission, item 20.
Item 20, my lord. I am filing the affidavits today, my lord. It was prepared yesterday, but could not be e-filed, my lord. I have given copy to my learned senior advocate, the amicus curiae, and also advocate Mrs. Paddy. I have given copies today.
Yes, what have you stated?
About the suggestion of Madam Paddy, we have taken steps for putting in the web and there is no teaching facility as the Lordship's queried about in web. So that part is being it is under consideration. Only one thing we have positively done is we have already increased the calories of laboring prisoners. Accordingly, it has been carried out.
Convenience, we are just giving a hard copy.
Yes, yes.
Your Lordship want to see it.
My lord, I am giving a hard copy, which is there. It has not yet been e-filed, my lord. I may excuse, my lord.
Do you have any open jail here in Odisha?
One open jail is there.
Where?
Bhubaneswar, Biju Patnaik.
No, that is not an open jail. That is a misnomer.
Named as.
And if you want to have open jails, you will have to have it in every district, at least one in every district. And you should do something.
Yes, sir.
Your Mineral Development Fund. Can that not be used for this?
Mineral Development Foundation
Yes, yes.
fund. Can that be used for maintenance?
Districts, yes.
Yes, yes.
The list where the resources are.
I think it will cover also welfare of prisoners. I think it should cover that fund because it is meant for the public good.
Yes, yes.
And development of that area.
Yes, why can't we think on that line?
My lord had already told the government
Yes,
regarding this open jails. My lord had visited and then even this jail, there are some problems. Those reports are repeated.
That is what had visited.
So have you cured? Have you considered the issues which are?
Well, we have not yet. My lord, I will put it before the government.
I think in the committee, my learned senior might not be aware. In the committee, there is a proposal of opening an open jail in the Sundargarh area. One jail.
No, one jail will not do. One jail will frustrate the purpose.
Okay.
You can have small places.
Yes, yes.
But in every district. Then you can select prisoners.
Even adjacent to the regular jail, that can also be put.
Oh, you can do that.
Yes, yes. I will take instruction on that, my lord. I will take it.
Take instruction. Where is the order, Mr. Mishra?
That's order number 65. No, my lord had informally proposed. So far as this open jail, my lord had informally. And so far as the previous order, if your lordship would like to see that, order number 65 dated 26/9/2024. That was vis-a-vis the website development.
Order is at page 645.
Probably 65, order number 65.
Yes, 65 is not getting the point.
Yes, have you complied with this order?
My lord, my lord, para 3, my lord, the suggestion of the amicus curiae and is there, A to F, my lord.
Yes. And 4, para 4 is the reply.
Yes, yes.
4 and 5. At
4 and
page
5.
3 of the affidavit being given today.
NIC has.
NIC has been approached
They have in principle they're not saying no, but they have attached 2 conditions. One is costs and the other one is NIC has
No, cost is not, it is only to ask for budgeting the thing.
And NIC has to
come up with the
cost and the software.
NIC agreeing
the
to
cost is necessary because you have to budget it. That is why.
And the software has to be developed.
Yes, software has to be developed. It will be implemented, my lord. This is a
Mr. Mishra will take up the matter in the next week. Right. We want a separate proceeding, writ proceeding instituted for open jails, each and every district.
Yes.
Please do some exercise on that. All right. In the present proceeding, it will become like so many things.
I agree. Because if this portal is developed, then majority of the issues which this court is looking into would be in an automated mode.
Automated.
That, that will be as far as regards the
Issues of overcrowding and all. So there would be
So
checks and
we'll take up
balances.
this matter in on the next day, next week. The next Wednesday, let's this matter next Wednesday. And let the affidavit which has been affidavit we filed on people and AGA intends to file an affidavit in the light of this court's order dated 26/9/2024, passed in the present batch of writ applications, the present public interest litigation. What's wrong?
Today.
Yes, yes.
Today.
We have also sought copies, my lord.
This so and so within so and so as the first case. In the meanwhile, you also work out, and I'll ask the legal service authority also to work out on the idea behind open jails.
Yes. One suggestion, if I can give, if your lordships are thinking in those lines, it can be suo motu also.
Suo motu, we will take up suo motu.
Yes.
We will on the next date. On the next date, we will direct based on whatever material you supply. we can, so that the suo moto proceeding be not without any material. So
This
let
should
there
be a
some
part of
material,
the, this jail
some
reforms matter.
foundational material.
I would
Then we-
definitely do the research.
Let a digital copy of the affidavit, which is intended to be filed, be placed on record.
In item 21, my learned friend has filed a rejoinder. The copy has not been served to me. Let him serve a copy.
I will give in the course of it.
What is this matter about?
Upgradation of the post of programmer in this course establishment to the post of system analyst, the next higher post. I will give the copy in course of it.
No, what is, let me see.
My lord.
This is Das as recused. This is Das as recused.
Let's see. The prayer.
The post of system analyst.
Post of system analyst.
Yes.
To the post of system analyst. He is in the post of programmer. The next below.
No, he is there, but you have
Mal-
asked for upgrading the post.
My lord, yes.
Under which law?
He is now eligible for that post, and since 2016, he has been continuing in the post of system analyst. Because initially they were appointed in 2024, both the programmer
Prayer
and
should
system.
have been to adjust the petitioner in that post, not to.
My lord. And
He is continuing.
in 2016, the other man resigned, and since 2016, the petitioner has been performing the role of that system analyst and also programmer. And in accordance with law of the government, in the government, he has 8 years experience and he is entitled to promotion. But because these are ex-cadre posts, there is no rule regarding promotion. Both the posts are
Why did you file this writ petition?
earlier, I have not filed writ petition. My writ petitions, 2 petitions were filed, withdrawn. One suo moto petition was there by this honorable court, initiated by this honorable court, wherein this honorable court directed that the post be upgraded to the post of assistant registrar.
Suo moto.
My lord.
Where is that?
I have given the order. Direction. Your lordship will kindly see. I have quoted the paragraph 6.2 in that order, that judgment, page 4, last para. In para 6.2 of its order, dated 3/1/20, passed in the said case, who directed page 4, madam, page 4 of my writ petition. May I place it?
No, we are trying to understand what was the circumstance in which this court had to take up some suo moto proceeding, that too in relation to its own employees.
The entire order is at page 12 to 20 in the counter. The entire order.
Oh, that was taken up in 2014.
So then
Well,
order.
No, subsequently that was modified on the complaint of the employee association.
File your rejoinder, we'll see.
My lord.
He has already filed that copy, not
Serve
served.
a
Let a
copy.
copy of the rejoinder affidavit be served on State Council and AGA. By what time?
Today I will finish. Today I will serve.
1 week. Yes.
Item 22.
Your lordship, similar matter, your lordship have posted to 5/11/2024. Batch of matters your lordship have posted with respect to that Narsu Pradhan and regularization of the entire service period. So, this matter.
They are
That
coming
delay has
on
been
which date?
controlled. Hello.
They are coming on
They're coming on 5th of November.
5th of
5th of November.
Okay. This is matter on 5/11. How long is it? 4/32 of 2022 and back. Yes.
Item 23.
Item 23, your lordship may see order number one. Initially, the state was directed to take instruction whether the governing body has been constituted for opposite party respondent number 3. On the last date, the respondent number 3 has entered the appearance. Your lordship. Yes.
Yes, madam. We have sought for instructions as to if the governing body has been constituted and approved. We have not got the information.
You are appearing for whom?
The respondent number 3 in this appeal.
Who is respondent number 3?
Aeronautics Education Society.
It is that institution where the appellant is the employee. So you don't know whether there is any governing body of the.
The confirmed information has not reached us.
No, that governing body has not been formed because they have not submitted the, I have taken, no. They have not submitted the proposal for which that governing body has not been approved till yet.
The peculiar circumstances, your lordship, the appellant, with the direction of the Honorable Single Judge, the appellant was directed to be to join the post where he had initially joined as the lecturer. And he's drawing also, he's only allowed to draw that much salary which he was allowed to draw in 1990, your lordship. No, but what is this college?
That may be a separate cause of action, not from out of the original order passed.
He'd come up with a prayer for getting, I think, approval of his post as vice principal. The court directed that since his promotion to the post of senior lecturer has not been approved, so he will continue in the post of lecturer.
Yes.
That is the order that he is challenging, and there we had asked to find out if governing body has been constituted.
Let me get the confirmed information as to if the governing body has been constituted and approved in the meantime.
You are appearing on behalf of?
The respondent number 3.
Okay.
Where are the rules? 1991 rules. The college should be closed then. The college cannot function without any governing body. Where are the rules?
That's the 1991 was that in the education manual. Your Lordship.
43, page 43.
How the college can function, madam, without governing body? Simple mockery of the system. That you established an institution which does not have a governing body, which is required. Also, which is the rule?
Yes, ma'am. 99.
Like your name, you're flying in the air.
Well, if this is the book, my lord, that page 681, may I give my lord?
By the way. Aeronautics college.
So fake, they are fake institutions. Who established it?
The society, the aeronautics society.
Aeronautics society, they cannot. Where is the rule?
At 681, Your Lordship, that the
rule number.
Constitution of that 21.
Establishment of.
Lordship, you can find it from page 688.
These litigations should not be fought whether he is a lecturer or principal or we don't recognize.
Rule 21 Constitution and Rule 23 Reconstitution.
Recognition, everything else has to be there. Thereafter, all this.
Yes, ma'am.
Rule 17.
No, ma'am. Constitution, Your Lordship is looking at that page 688. That is the constitution of the governing body in respect of a new college. If that after constitution is the reconstitution provided under Rule 23.
Yes, provided they had a governing body earlier.
Yes, yes. Ma'am. In respect of new college, first constitution, that is
Yes.
21.
Yes.
So this is not a new college. This
17 also granting recognition shall specify the governing body approved for the college with the name of the president and
So when was the
secretary.
college established? We are
That
not
it is-
here for
it
entertaining
appears that
unnecessary
it was
disputes.
established in 1981-82.
81.
Well, as it appears from his paragraph 3 of the read appeal, sorry.
With permanent recognition from 1993 and permanent affiliation from 2002.
And when were you appointed?
1990.
Annexure 4, I think. Annexure 4?
Lordships. Annexure 4.
Permanent recognition, they've given annexure 3, which we can't read. We given a type copy, all right. All right, I got recognition. Subject to fulfillment of conditions. If this is +2, Mr. Kuntia,
Well,
this is +2 college.
+3 is also there.
Or +3 also, all right.
This is the college, my lord, Your Lordship,
Yes,
look,
yes.
private colleges.
Yes, no, because +2
Yes, but
also
government
recognition
application and
granted.
everything is there.
Yes, +3 is also there, subject to fulfillment of conditions as prescribed under section 6.
So what is wrong with the order?
Your
There
Lordship,
is nothing wrong.
the issue here is that I did come up against the disciplinary action, saying that that particular authority does not have power to initiate disciplinary action against it. Now, Your Lordships, the court did accept that. What the court did is, has taken me back to the position of being a lecturer. Now, this is not something which is my fault, Your Lordships.
Maybe, but that was illegal.
Your Lordships, the entire, the college has all the benefits and everything has accrued by this authority who issued all the promotion orders and everything. Your Lordships, you look at Annexure 5 actually. It's not only me.
No, but please let us know how do you claim that you are a recognized institution?
Your Lordships,
Not you, you're the college.
They have given us affiliation, Your Lordships. The government authorities have given us affiliation and
When?
recognition.
The affiliation was given when?
Your Lordships will look at that document, 4 series, Your Lordships. 2 series.
When?
26 onwards.
When? What is the date?
Your Lordships, the first one is 8/2/1993.
8/2/1993 affiliation was given.
Lordships.
Under which provision?
The first two relate to +2.
+2, yes, +2 arts, commerce and science.
Yes, +2
And
then that is all. The Annexure 2 series relate to +2 higher
no,
secondary.
Your Lordships will look at then again 24/10/2022.
Which
Sorry, there is further affiliation.
Page
27.
That again says higher secondary.
And then Annexure 3.
Annexure 3, you're given a type of 3 years.
That's a permanent recognition.
Yes, that which I was referring to earlier.
Lordships, where +3 science, arts, commerce is also there.
No, you were granted recognition under which provision?
So, Lordships will look at this quotes it, Section 6C of the Orissa Education Act 1969. Page 29. 6C.
And what is this Orissa Education ERMTC rules? Management of private college? So you are governed by this?
Orissa Education and Established Recognition in Management Private College 1969.
And how are you are principal?
No, me. No, I am the society.
You are the society.
Yes.
So why managing committee has not been constituted?
Yeah, that instruction I need to have. The governing body.
Governing body?
Unconfirmed information we have received that it is constituted, but about approval by the government which it needed to be there.
+2, +3, you have to have 2 different bodies.
Yes.
What is this society? Who heads this society?
Aeronautics Education Society.
Who heads this society? Who is the chairman of the society or secretary of the society? The prima facie, we are of the view that it's a fake institution.
It's not
because you are the society and you establish this institution. You don't know whether the managing committee is there or not. The managing committee has not been constituted. You are yet to seek instructions whether the managing committee is there or not. It is a specific stand of the state that there is no managing committee. What is the kind of this institution, and we are entertaining the litigations unnecessarily.
Your Lordship may call it a week after.
What week after?
We'll see that if it is sent to government for approval. And
the Education Secretary, Government of Orissa, file a detailed affidavit as regards
higher education
status of
higher education.
Higher education.
File an affidavit as regards the status of the present, which institution? Which college?
Education Society.
The Aeronautics Education Society.
What is the name of the college?
Aeronautic College. Aeronautic College.
Aeronautics.
Recognition is for Aeronautic College. 329. Madam.
What is the name of the college?
Oh, there is one Aeronautics College, there is one Aeronautics Commerce and Arts College. You were appointed to the Aeronautics Commerce and Arts College as per page 30. Recognition has been given to Aeronautics College.
Aeronautics Commerce and
And
Arts.
you have not implemented even the college a party. College is not a party.
The lower court, this is exactly what was the cost title. I mean, the cost, sorry, before the single bench. This is
So-
exactly what.
So you are the petitioner.
You have
what I
filed
mean
it.
That.
Exactly. So we are referring to that only.
Secretary file a detailed affidavit. Right from affidavit stating, disclosing the status of
Page 35.
Aeronautic College. Sunabeda,
Sunabeda, District
Suna-
Koraput.
Sunabeda in the district of Kolhapur. Right from its establishment
Is the reason for it.
till the till date. So the secretary will call an inquiry to find out as to whether the affairs of the college are in accordance with, are being conducted in accordance with the statutory provisions, particularly Orissa Education Bracketed Establishment Recognition and Management of Private Colleges Rules 1991. And whether the state was required to take any action which it has failed to take or any deficiency. Yes.
I think the reason why the college was not implemented because all the impugn orders have actually come on the letterhead of the Aeronautics Education Society. Maybe that's the reason why the petitioner before the single bench chose to, and it's by the General Secretary of the Aeronautics Education Society. So it's
You
not
are-
really being.
But you are the employee of the college because it is stated so and so
Yes,
principal.
but the impugn order which was there, I think that's maybe the reason why the petitioner did not. Just
Yes. 2 weeks.
Item 24.
Pursuant to the direction of the Honorable Court, in fact, the affidavit was e-filed yesterday on behalf of the government with respect to the decision taken by the committee. I'm also filing the hard copy that may be taken on record. So also I am serving copy on my learned friends.
Yes, you can see.
Go through it, my lord. My lord, will be a copy. I'll go through it.
Next Wednesday.
Let's first.
File it in the registry.
It is already e-filed. It is already
E-filed,
e-filed. Only the certified.
Only one more thing.
Yes.
Both the OPSC and the State Council now filed an affidavit by stating that 192 is the cutoff marks. Your Lordship on the first day told that the cutoff mark will be, fixation of the cutoff mark is, suppose there is 100 posts. What is the last candidate secured the mark? That 100th candidate secured the mark, that is the cutoff mark. Neither the OPSC nor the State Council give the list of the names. These are the 100 candidates. Post 100 are filled up and the top mark is 180 and 100th candidate has secured 120 or 130 this mark. Both in set of the cutoff mark.
We'll consider.
Cutoff mark is not something which has been fixed in the advertisement. Unless you fix up, score this mark.
Cutoff marks will depend on the comparative marks scored by the candidates.
Yes, ma'am.
It may vary.
It may vary.
It may vary.
But
it is not that something is fixed and.
But neither of them has filed any affidavit stating how 192.2 has been fixed at the cutoff mark.
All right.
Yes.
Why it was taken as cutoff mark?
Cutoff mark. Yes.
So the mark of which candidate?
Which candidate? Which candidate has secured the lowest mark that has been taken as the cutoff mark?
All right. Now everything is in public domain.
Yes.
Everything is everyone knows everyone's mark. So it is not difficult for even the court to decide the merit list.
All right. On Monday, I will give my response.
Wednesday. Monday is.
Monday, I will file with copy to both of them.
Monday is open. All right. Let it come on Monday then.
Monday, I will file my.
All right.
I will file with copy to my friends and let the matter be taken up for list.
Wednesday.
Item 25.
May I please, Lord? Just to recapitulate the matter relating to that. But I just like your lordships to know that cell, what has happened. I'm not praying anything at a time. Unless your lordships are right, unless the order of the Honorable Single Judge saying that the cell is void goes, how can a right come to me? That's your lordship's view, expressed last occasion. May I tell your lordships how now I'll say on that how the order of the single judge is bad in law, prima facie, to your lordships. Then only your lordships will be inclined to give any interim order or a final order that. But what has happened in this case is relevant, my lord. I am the appellant. The appellant runs a hotel, lord, a hotel at Puri Pitch. This hotel was purchased by me by registered sale deed from 2009. I have purchased that property from a person who had purchased in turn the property from 1993 from the intervener opposite party 3 and 4, who were our neighbors. They were the land, they had sold the land in 1993. But these are all, this is a different, which you may be familiar in, maybe in different states. These are all khasma lands, called khasma lands. And there's a particular law and procedure how this property is to be settled with anybody. When in 93, the person who had purchased, my lord, had sold me, he had applied for renewal of his land to the statutory authorities under the Government Land Settlement Act. But I'll bring to your lordship's notice that the law is whoever is in possession and occupation of the land and of the khasma lands, and this right is transferable, heritable, and automatically renewable. That means he's the full owner. There is no discretion of the government not to grant it. But in this background, my lord, in 2003, when this was going on, when I have arrived, that the person from whom, my lord, you will also kindly keep that, but I am not taking your lordship to detail where is the annexure, what is, because I have given your lordship idea, then your lordship can put queries on me, where is what. My lord, kindly, sir, see, when he applied for land, sir, before the Khasmal authorities, thereafter, the application was pending before the authorities. In fact, my lord, it is on record before the Honorable Single Judge that the Tehsildar has recommended for settlement of the lease in my favor. Lord Lordship, kindly keep this as a very important facet. Tehsildar has recommended to the collector, to the sub-collector, and the sub-collector also recommended, and that means my status is my application for settlement of the land under the statute is pending before the collector. That is my status of land. But while this status was pending, my lord, what happened, my lord, OP number 3 and 4 as my neighbors, I mean, they could have some legitimate grievances against me that I had some problems or content some mischiefs or thrown some debris. They complained, sir, to the Human Rights Commission. Well, this is a point you'll also kindly keep in mind. Where does the Human Rights Commission assume jurisdiction in all these matters? It's a matter of great doubt, my lord. Anyway, my lord, he went to Human Rights Commission. Human Rights Commission directed all authorities under the sun, including the pollution control, including the collectors, that you see that whether he has land rights, whether you see he has pollution, whatever, he directed. But what happens, my lord, my application for pollution was for the grant of approval is pending by then before the pollution authorities. Because of the order of the Human Rights Commission, they hastily rejected my application and said that you close down. Well, that was the order passed in 2023, which was impugned before the Honorable Single Judge. But what he was impugned was, sir, that means if a writ is dismissed, I go back to the stage where that means my application which is rejected, then the authorities will consider. So when the authorities, on the basis of Human Rights Commission, I said came before the Honorable Single Judge, that this is not correct, that the Human Rights Commission directs and you are immediately without any opportunity shutting me down. So that I challenged before the Honorable Single Judge. But before the Honorable Single Judge, my lord, this is also an important question of locus standi. OP number 323, my neighbors, not the pollution control, that was not an issue, come up with a plea before the Honorable Single Judge that my right itself is void because I have purchased the land from the original lessee after expiry of the lease. This is the contention of, Lord, why I am submitting that, Lord, OP number 3 and 2 and 3 would have no locus standi to challenge the validity of the title of my property. They have no lease with me. Lord, it's like, sir, my lord, when my house at Cuttack, my neighbor says that I have not an absolute right, my sisters have right, or my others have right. So in any case, 2 and 3 had no locus standi. They were interveners. They could only confine to their allegations that there's some mischief is being committed, some debris is being thrown at their hotel. What happened, my lord? The Honorable Single Judge, what happened? First said, this is a neighborly dispute. You both sit down and resolve the dispute. That could not happen. If that did not happen, he comes to a conclusion, my lord, now that the sale is void. That part of the order, my lord, is the major issue. Only that, and now because the Honorable Single Judge has directed sale is void at authorities, it is a cascading effect. Obviously, the authorities of pollution have no scope. The authorities in appeal have no scope because the Honorable Single Judge has directed. Now, in this background, sir, kindly see the order of the Single Judge.
No, but the issue was raised, the Human Rights Commission.
Yes.
By
3 and 4. By my neighbors.
Yes.
Yes. Yes.
They have a private residence?
They have another hotel. They have another hotel.
That is not the question.
Sir.
The question is that from any source,
sir,
it was learned that you did not have the title.
I humbly submit, sir, it's not a question of any source learned. Human Rights Commission is for human rights violations.
You did not challenge that order.
No, I challenge the effect of that order. I'm not, again, Lord, I am a victim of
All
the
right.
circumstances.
And the Human Rights Commission did not pass any order.
He directed every authority
The
to direct.
Human Rights Commission just said
Yes.
that you examine,
Yes,
nothing more than
yes,
that.
yes, Lord.
And upon examination, in fact, we were initially under the impression that the issue of your title was not a question before the learned single judge. But it appears from the order of the commission
No,
also.
commission's order, my lord, is not a matter for consideration. What is it? The issue of title was raised by OP number 3 and 4. I went before the Honorable Human Rights Commission, raised that matter rightly or wrongly. I am not now also. What I went to the court, sir, was a order passed by pollution authorities that in view of the Human Rights Commission, this was an impugned in a order passed in 2023. I went and challenged that. In fact, the Honorable Single Judge also passed an interim order that what I humbly submit, if I am not clear, my lord, my title is an issue. My title is an issue. A, who can raise it?
Anyone can raise it.
No, my lord, my title cannot be raised by anybody.
Your title, see,
My lord, I like
your title vis-a-vis B or C may not be raised, but if the title is between you and the government.
No, government, of course, it is not between me and the government.
Yes, it's a khasmal.
It's a khasmal. Your lordships now can take into consideration. I'll just tell your lordships that what is my status is, as per the government, is that my application is pending. So how can my right be invalid?
That is different.
Yes, my lord.
See, you may be correct in your submission.
Sir.
But questioning his locus standi, he may not have any locus standi.
Yes.
But the court had.
My lord, what I humbly submit to your lordships that the court normally decides a list which comes up in a
not writ court.
Yes.
Not writ court.
But writ court, see, yes, I am not. I will just say, my lord, answer that what is my right? What is my status?
That is different.
Yes, I'm not. Honorable Single Judge has said that what you have said that since you have what the Honorable Single Judge has said that since you have purchased the property, the khasmal property from a person whose lease has expired, your right is void. That's not the law.
So therefore, you have to address that point first.
Yes, that's what I'm addressing. But before that, I came to your lordships. I also said to your lordships to keep in mind the locus standi. Keep in mind that the government has not challenged my rights. Keep in mind that OP number 3 is a hostile number.
Question of locus standi becomes meaningless.
Yes, after a court comes to a finding. The court need not have come to that finding, but since it has come to a finding, your lordships cannot ignore it. I don't dispute in the proposition of law that your lordships cannot ignore this finding once it has been said by the Honorable Single Judge. But I'll straight away, lordship say that what is my status according to the government is like, my lord, I got an RTI. I just, if your lordship don't mind, my lord, I'll give it by an affidavit. But
what is that? Please,
yes, sir.
Please.
My status is, sir, that this Tehsildar, as in 2024, has directed the sub-collector that as per the Government Land Settlement Act, the land be settled with me, is my status. Be settled with me under the Government Land Settlement Act because I had purchased. The original applicant was my vendor. He had applied. I stepped into his shoes. His right accrued on me, and the Tehsildar has is submitted to the collector, who is the authority, to settle it. It went through the usual channels to the sub-collector. The sub-collector has also recommended matters pending the collector. That being the position of law, can my lord, on a submission only made by it, that I have purchased.
No, but where is the question of settlement?
Sir.
Not a question of the land, according to you, was settled in favor of your.
No, it is all khasmal land, sir. What happens is a settlement. How is it? I'll tell you lots about this settlement. In fact, I was myself not very clear of this land law. Still, I clarified myself. Khasmal lands are lease lands given by the government, whichever in Cuttack, Bhubaneswar, Puri, or over the state. These khasmal lands, when are given a lease, the lease has a particular period. And the period or expires period or before expiry or after expiry.
Depending on the terms of the lease, that can be perpetual,
That customer land, the government has come with a law that all these customer lands where the persons are in occupation shall be settled with certain premiums. Obviously, it has certain guidelines of premiums, how much you have to pay, are to be settled with the persons in occupation of the customer lands. This is the law. Following that, we have several judgments of the High Court. There are several judgments of saying that how customer lands should be. And following that procedure of law, the Tehsildar has recommended to the collector, who is the authority to grant, to settle in my favor, which is pending before the collector. So my status is...
No, see, there is a difference.
Sir.
You purchased.
Yes.
You purchased something.
Yes.
What did you purchase?
I purchased the rights of the...
The rights.
Yes.
All right. So the land was initially settled.
Initially was leased. What?
Initially was leased.
And he had applied, sir.
All right. So the lease period had expired.
Yes.
The lease period could be extended.
Yes.
Or in terms of the lease that may be perpetual. We don't know.
It's perpetual, sir. Yes, as per the law.
No, not as per the law. As per the lease agreement.
The lease agreements are after these agreements are expired. The law says now that after the lease agreement expires, it has to be settled on settlement. That's the law of the Government Land Settlement Act.
That after lease, this is the law in Orissa.
Yes.
That after the lease,
if a person applies,
period
in his occupation,
lease
it shall be settled.
It shall be settled. Where is
Certain
that?
terms and payments and...
Where is that? Let us see.
Sir, kindly see, sir. May lots the whole and the recommendation has been done pursuant to that.
Let me
yes, sir. Kindly see, sir.
So when did the lease expire?
The lease, yes, I'm telling sir. Give me a second. I'll just give you lots of yes, Schedule 5. The law, sir, is as per the Schedule 5. I'll just give you lots of the date also. In the meantime. 98.
95 expired. 18/1/95 expired.
Your lordship is Schedule 5A, your lordship is.
Yes.
Yes. This is yes. The subsection 4. The influences got the section 3.4. That starts from section 3.4, then the 5.
Section or
no, that's a schedule. Schedule comes after that section. Schedule it refers to
Schedule 5.
No. Yes, you'll also see the Schedule 5.
Section of what?
Of the Odisha Government Land Settlement Act 1962.
Section?
So section
6, section 3, subsection 4.
Section 3.4. Sir. That section 3 bracketed 4, notwithstanding anything in contrary content preceding subsections or any law or custom, practice or usage, any land or the category of khasmal, this is khasmal, sir, wherever situated and used for any purpose may on application be permanently settled with heritable and transferable rights to the person who is in occupation of such land either on basis of lease or otherwise for a period of at least 3 years prior to the appointed date. In such manner and subject to payment such amount the government has
Just a minute, just a minute.
Sir. In this context, sir, we will also like to rule also, rule 5BB, because it also refers to that. 5BB of the government land settlement rules. 5BB of the rules. Capital B. 5 capital BB.
Yes.
Notwithstanding anything contained in rule, settlement of khasmal, leased out and etc. and but occupied for a continuous period of 3 years prior to 5BB. Government Land Orissa Government Land Settlement Rules 1983.
No, but why? What was there before this 22/10/2021, 22nd October 2021? There is amendment. So what was there before that?
Yes, I'll check up, sir. I'll check.
And here also, the provision of the act which you are referring to.
Your lordships are referring to section 5?
Section 5 also?
Yes.
Section 5. And then.
I'll give you lordships the old also.
There have been amendments in 2021.
In 21. My lord is referring to amendment in 21. Amendments in 21. I will.
What was the earlier position? Please.
Yes, sir. Yes, sir. I will assist. I will try to do. Assist. Whatever is the rules and what your lordships have seen that Tahsildar's recommendation, my lord. So what what I'm saying that these are not facts before the honorable single judge because it was done on the basis of 3 and 4 submission that my cell is void. 3 and that government did not take. This your lordship would just have that all this goes set at naught because of the order of the single judge. Nobody will proceed and give me any lease which is recommended by the where government has not raised it. Government, in fact, is saying that that your lordship see only this part of your lordship see. That's order.
And whether the government is a party?
Yes, government in party. Yes, government. Yes, government was the party. Government was the party. They have the collector. My status is the Tahsildar has recommended to the collector. This is my status.
So please
Yes,
give him a copy of.
I'll also give this. So what I'm humbly
because see, you cannot get any relief unless you get over that observation.
Yes,
made by
what I will say. I'm totally bowed down to your lordships that I cannot get any relief unless I get over the observation. What I'm humbly submitting that the observations A is from nowhere. B is not based on any government because my right is vis-a-vis the government. My right is whether I will given a right or not is the basis of my application is to the government because it is a Khasmal land and the government record says that my right to be granted lease is proposed to the collector.
We will see that.
But it's nowhere, sir, before the.
See,
Sir,
Mr.
before your lordship says nothing is there.
It is in your interest. It is in your interest that dispute is resolved.
Yes,
In any
that's
proceeding, it is good that you have-
I totally bow down to your lordships. If my rights are not there, right, I will put it rightly or wrong.
Resolve either way. Like if it is decided in your favor, that
what
will be for the future also.
Yes.
If that is decided against you,
Yes, obviously.
but we will have to address that issue.
Yes, I don't dispute. What I humbly submit to your lordships, I am also trying to address that issue only now. Nothing beyond that. That the findings of the Honorable Single Judge, finding has been given, but based on nothing. Except a submission by the intervener opposition 3 and 4 that my cell is void. It's not a civil proceedings. It's not a proceedings me vis-a-vis the government. It's not that anybody. It's just a finding because he says that since you have purchased he has not gone into the Gram Settlement Act. He has not the fact that what is the status of my land. He has not asked the government that what is my status.
Therefore, we will have to be satisfied that because of those provisions,
yes, and because of
some semblance of right.
Yes, sir, because of the
Some
provisions and because of the recommendation, because the matter is pending in the government, that's your lordship to satisfy.
Let us see.
Yes, I don't dispute my lord. If your lordship are not satisfied on this, yes, if your lordship are not satisfied on this, I cannot proceed.
Serve a copy on
yes, sir.
Seek the instructions, sir.
Yes. Only thing that urgency your lordship knows I did not
Urgency, we understand.
Urgency time and again. I will serve a copy again. I will not reiterate the urgency. I will not say any except that this is the position, sir, where the lordship is seen. And I mean, my rights of last 20 years has been taken away by Honorable Single Judge, which is not an issue, not the least, not anything, not Government Land Settlement Act, not referring to the government, not asking the government what's my status. Only on the submission of OP number 3 that my cell.
Whether the lease documents were there on record.
The lease documents means not lease documents, my lord. So far as my cell deeds were there, nothing else in record. In fact, in what was there before the Honorable Single Judge also not referred to is that the Tehsildar also said an order that my matter is pending for settlement. That was there. For
That doesn't give you any right.
What I'm humbly submitting that while taking away a right, only because the Honorable Single Judge has done, while taking away a right, it's like negative proof. Right? I am coming before lordship that he had no basis to write it. That's your lordship's first. Thereafter, your lordship may like to be satisfied that whether I have a right or not. But first, I will satisfy your lordship that he had no basis to come to a finding which he has. That is my prima facie. Yes. Lordship may just after any date may be fixed. In the meantime, today I'll give copies.
Yes, Mr.
Yeah,
I'll take some instructions.
I think yes, if Mr.
Mr.
Samantra has more experience, then you can seek.
In fact, one thing is that not the entire town of Cuttack, the land is Khasmal land.
Yes.
No, but that is everywhere. It is not what he is saying. It is not that I am completely ignorant of the law relating to Khasmal. It may be that you may have more experience or you have more experience, but yes, Khasmal is everywhere. Depending on the terms of lease,
yes,
and depending on the scheme,
only statement, my lord. Earlier, these
in every state is the situation that the terms are not being extended, the applications are pending with the authorities, the leases are fighting their rights.
In fact, there are large number.
There must be issue of conversion of user, like generally the leases are granted for residential purpose.
Nice.
When you change the purpose, then also that may also sometimes that is also ground for cancellation of these are very common and it's not specific to
only to make just some submission. Lordship, kindly let me refresh your lordship's memory that the last occasions your lordship was to
find out from the writ petition. In fact, what is the challenge? What was challenge? In fact, what is addressed, that is not the challenge. Challenge that without obtaining consent to operate the hotel, we
Understand that. See,
that is also the point decided. That is also point because without consent, you have
the difficulty which we have is that a finding has been recorded. You are assailing that finding, and unless you get over that finding, it is difficult for you to get any relief.
Right. But on that
that finding can be interfered with on two grounds. One, there were no material before the learned single judge to reach that finding, and two, the finding is incorrect because of the legal provision.
Legal provision.
These are only two things.
I can't improve on that. I can't improve on that. I can't improve on that.
But in any case, we will have to address only because that was the issue which was to be decided, and therefore, and on the next date we can give us that, see, these were the materials before the learned single judge. And on these materials, these issues could not have arisen, and therefore the issue could not have been decided.
Sir, as your lordship, may I just repeat what your lordship fallen from your lordship? Two issues. Was it a matter for which there is material for him to decide? And even if there's no material, whether the decision is
exactly.
If the first goes, the second may not be necessary.
Yeah.
If the first survives, still we have to prove that on law it is not correct. That is all. Because
second also you will satisfy whether that
second, if your lordship,
without consent, my lord, running the hotel without consent, that's the
consent. I'll go back to the stage of running a hotel without consent.
Without consent, they cannot run for a day.
Who is saying?
They are running. They were running.
You have closed down and shut down what running.
They were running.
It is closed only up to the judgment. So illegally it was operated.
May I say?
Already, my lord, pollution was there.
What is that issue? If it is the issue of pollution, let it be confined to pollution only.
My lord,
why go beyond it?
Discharging the water without treatment, without ETP, and without.
Why are you so sure that we will not address that part of the dispute?
Right. We should wait for that.
Very well, sir.
Yes.
Great globalization.
This matter on next Wednesday. Let it come on next Wednesday.
2 weeks time.
Next Wednesday, huh?
2 weeks time.
Monday we can take up.
He's saying
if it comes on Monday,
13th,
all right. On 13th is what? 13th is Wednesday. Better let it come on 12th. Because sometimes Wednesday we have only first half. Second half I sit single. And if for some reason that is to be adjourned, then it will again take further time. So let it come on 12th.
Yes.
If required, that it can spill over to 13th.
Yes. May I remind your lordship that the matter to be taken up, or it depends on
No. We can.
Whatever your lordship decide.
Well, within first 10 cases. First 10 cases.
Yes. Grateful.
Item 26.
And you can get a judgment from Patna on this Hasmal.
Yes, sir.
By Justice Jyoti Sharan.
Yes, sir.
That deals with
Hasmal.
Yes.
There are judgments of High Court. I'll get it from Patna also.
Add only one sentence. Earlier, my lords, we were covered that so far Khasmal law. The Bihar Odisha Khasmal manual. Dealing with that Bihar Odisha Khasmal manual in the year 1976, our Honorable High Court in a division bench decided that these are all heritable and transferred like that of a private party.
Does see that decision? That is also quite elaborate.
That was confirmed in Supreme Court.
We'll get the judgments also on Khasmal. Grateful, sir.
26.
May I please, your lord?
Under the petitioner prayed for to get the stipend, that is the petitioner's ST students who are prosecuting their studies in the ITI colleges. They, after admission in the ITI college, they continue their study by the getting stipend from the government. Madam. They have selected by the state government through SAMS portal, and they are admitted on merit to the concerned college, my lord. Thereafter, their names have been sent to the state government for a stipend. But the opposite parties had not given any stipend to the concerned petitioners till today, my lord.
Yes.
Thereafter,
yes, my lord, I have got that instruction on last occasion. Also, I directed them to take instruction why they have been debarred. They have given that instruction as per the guideline issued by Minister of Tribal Affairs, that they have been denied that at the educational institution where they are prosecuting, that does not satisfy the system for which they have been denied. But I have seen that guideline. That guideline that is perhaps not applicable in respect of diploma and ITI. So let them file an affidavit. That instruction is contrary to their guideline. I've seen that instruction. So let the government should file. I'll file an affidavit clarifying that, because I've seen that guideline and also instruction. My instruction is contrary to that guideline.
2 weeks.
Yes, my lord. Next week, my lord. The petition have already completed 1 year, my lord.
Yeah,
maybe next week, my lord.
I have received the instruction. I have seen that guideline. In that guideline, that is not
Now
applicable.
They are promoted to second year course, my
Time
lord.
is allowed for the estate to file counter affidavit. Is this case 2
By
weeks?
the, you'll also miss that by SC and ST department, they will file counter affidavit.
Is allowed for which department? For
SC and ST
opposite
department.
party number?
SC and SC, Civil Caste and Civil Tribe Department, you'll also miss that opposite party number 2.
Let counter affidavit be filed on behalf of opposite party number 2 within 2 weeks. Post office this matter on 2 weeks. Yes.
Item 27.
That may be fixed.
This is item number 27. I filed my counter affidavit on behalf of 3 and 4 today itself, Lord. So e-filing I have already filed it. I will serve a copy on my senior minutes. Will also say served in court, Mills.
Copy of the counter affidavit has been served upon land counsel for the petitioner today itself. So stop. When do you want, Mr.?
Well, let's, can it be second week of November?
As requested on behalf of the petitioner, list this matter on 2nd of November.
12th. Second week.
Second week.
Second week of November. 12th.
Much of late.
Which matter? Yes. Record has not come, Mr.
That was my instruction. The rest is sending the file.
Sending the file.
Yes.
What is the?
Authorize the election can do in my file also. I have flag marked it. You also make and paid it.
Yes, Mr. Parekh.
I need your lordship.
There's a judge, he had a certificate saying Konda Dora. So that his grandfather was the Tahsildar did some verification and he produced an old certificate before the OJE and he gave an undertaking. So on that basis, he was admitted to Koraput Medical College. He's got a provisional admission. But we have a difficulty that by a particular date, he has to produce the final verification for the documents for the final verification. Apparently, in the meantime, the Tahsildar has cancelled that certificate saying that he is not in the presidential list. Konda Goda is not a scheduled tribe. Konda Dora. No. That judgment, the presidential order, you can't add or subtract to that. Then there's a judgment by Justice Sinha, single judge. The finding I was just going through in court, I just was served a copy, of course.
Manoj, I just, the last paragraph, the judgment. Kuta?
Page 50.
Huh. The same appellant, Manoj, those.
Yes, very same judgment was challenged by your lordship, along with minor justice Talpatra. They took it and didn't grant stay of that judgment. And thereafter he cancelled it in violation of this judgment.
Pending.
Writ appeal is pending. Now he has cancelled it.
Without a stay. And so I leave it to your lordship, Manoj, how your lordship will deal with it.
The second cancellation order was also challenged by me, by the Honorable Single Judge. And on 2nd of September, the order was, the interim protection was granted to me.
We will take up your matter on Monday, on the opening day.
4th, your lordship may take up, 5th is the last date for us.
On Monday, we will take up your
Lordship
matter.
may take up on 4th.
Confirm.
Monday.
Today is the last.
Today is the last date. The OJE has instructed me to produce the caste certificate by 5 p.m. Otherwise, they will send it to the city.
I will ask them to extend that by up to Monday.
If my
lordship will
ask them.
I'll ask
Since
them.
the records are not here, we should not pass any order.
I will ask them to, because it's your lordship hasn't had in session of the matter. I'll ask them to extend it till that concession they'll give. Till Monday evening.
Monday, first case.
Great.
The matter there. Right. Three matters.
See that ITA matter. ITA.
ITA.
Pass over one matter.
30.
Item 10.
Second.
Item 10.
Who is time?
Continue.
Item 10, Milos.
Item 10.
That interim order, your lordship will look at para 4 of the order. In fact, those petitioners, they had responded to the letter of the director on time. And so far as para 10 is concerned, that order, the last date was 31/8/2024. Whereas he has responded to the letter of the director much after that in the month of September, which is after the last date. So
it is mentioned that earlier he has submitted Milos his answer. Milos.
No, but he has submitted that.
Page 22.
Clearly stating not there. You have entertained those who are giving the replies and asking for time.
We will see what can be done.
It may be
On Monday.
My lord, this is an urgent matter. On 18 September, I have mentioned this for contempt petition of an old lady, and my lord has given instruction to the standing council to dispose of the case in 1 week. Otherwise, if no action will be taken, to remind it on next Wednesday. Today it's 30th of October. No action has been taken. So I'm here.
Yes.
You can take the number from my letter. I'll look into that.
Yes, give the number and give the slip also.
Yes, my lord. Thank you.
Given the number. Given the number.
Bye. Thank you. Thank you, my lord.
Case admission item number 1, ARBP 48 of 2024.
Application for appointment of arbitrator, fresh application.
Notice. All formalities complete.
No, my lord, it is listed for first time. If lordship issue notice, then we will take the inspection.
Yes, issue notice. You accept notice?
Yes. It is a CPW matter. I will
accept notice.
I will serve one more copy. Let's this matter on.
3 weeks. 3 weeks, Mr.
Obligement, yes.
Item number 2.
May I please, sir? I humbly pray, my lord, for appointment of arbitrator under section 11 of the Act 1996.
Press matter.
Press matter. Earlier, it was disposed of by my lord with appointment of the honorable arbitrator. Now, again, I have obtained liberty from your lordship to file another application, press application. That is why press application has come up before your lordship for appointment of arbitrator. Arbitration clause is found place at page 34 of
No,
my
learned arbitrator. Earlier, one arbitrator was appointed.
appointed by order dated 1st March 2024. That is a found place at page 124 of my lord's brief.
Then why again?
Because the honorable arbitrator has recused himself from conducting the arbitration proceeding since he has been appointed as president of the past president of GST Appellate Tribunal Principal Bench, New Delhi. That is why he has recused himself from conducting the arbitration proceeding.
So you were required to file substitution of arbitrator, no?
Because that is why I have filed an application for interim application that is found place at page.
All right, who is appearing for the other side?
Government, state government.
Yes.
Item 2, yes, my lords. I have no objection.
Should be appointed.
Justice Pramod Patnaik, retired arbitrator, retired judge of this honorable court.
Pramod Patnaik.
Yes, my lord.
All right.
Item number 3.
This page 1.
East Coast Railway, let them serve a copy.
171 is the arbitration clause. Page
Serve a copy,
171.
madam.
They can accept notice if you are. I'm just
They are accepting.
No, we will accept notice. No advance copy is given. That's why
Advance
only I
copy,
note that
actually-
East Coast Railway is the party. So
Yes, advance copy, and in fact, I think in arbitration, we'll give them. And page 209 is my notice.
Issue notice. Also accept notice. Does this matter? 3 weeks? Yes.
For orders, item number 4. Item 4. Item number 5.
Item number 4 and 5 both. In that case, my lord, we have suggested the name of Justice C.R. Das as well as Justice Akhairat, because the agreement shows that 3 arbitrators. But inherently, single judge's name has been posted, he has appointed the arbitrator. So for that's why we file an application for modification to the extent that instead of one arbitrator, another, they may propose it, and because the arbitrator, the agreement itself speaks about this.
When counsel for the petitioner is not here, we just adjourning.
I think somebody is
for the
appearing
petitioner,
for
my
me.
lords.
Yes.
I beg to appear for the petitioner, my lords. If I may point out, my lords, this is an IA filed for modification in a disposal of matter. My lords, this order appointing the arbitrator was 4th September 2024. This order has been passed on consent of both the parties, my lords. So, secondly, my lords, it was the which I have consented. It is their own nominee who has been appointed as the sole arbitrator. I don't understand what the objection is, because it will only defer the matter. Secondly, my lords,
let us see the arbitration clause first.
Yes. This is page 265. If let's say keep it item number 5, page 265.
Annexure.
That is annexure. Annexure 2 series, my lord. This start from page 25 to 276 of the item number 5.
265.
265 the item number 5, my lord. Page 265.
Just, 265 of annexure 1.
My lord, let me come to the next page, 266. There is a second paragraph. The contractor will ask to suggest.
Just a minute.
Sorry.
Two
266. Let's see.
266. Yes.
Yes. Second paragraph.
Yes.
They have to suggest another two names. That is
No. Where is the which clause you are referring to?
It is let's me come to page 265.
Yes.
Appointment of arbitrator. That is clause 64.3. The next is 64.3.
ARBP 10 of 2024. I'm seeing some wrong file.
In that case they have quoted, but the next case it is similar to this. And that case they have annexed the agreement. This general condition of contract is annexed in the next arbitration number 22 of 2024. That is next item 5.
Which page?
265.
Yes.
This appointment arbiter documents clause 64.3.
Yes.
Then 64.3A1. In case of the total value of the claim in question added together does not exceed ₹25 lakhs, as the arbitral tribunal shall consist a sole arbitrator who shall be the gazetted officer of the railway such and such, because now it is changed after the amendment 2015, nominated by the general manager. The sole arbiter shall be appointed within 60 days. It is a value of more than 25 lakhs. So next page it says they have suggested to another arbitrator, based on which adjudication will be made by the arbitral tribunal. That is next page. The next page, the contractor will be asked to suggest to the general manager at least two names out of the panel of appointment of the contractor.
Mr. Padhi, this clause cannot be applied for the reason that under this clause, the gazetted railway officers are required to be appointed.
That is old. I am admitting, my lord. It is
therefore, we have to just examine whether there is an arbitration clause or not. And it is because of the arbitration clause one arbitrator has been appointed. It doesn't mean that 3 arbitrators are required to be appointed because of 64(3). Different situation altogether. You can examine the aspect, the legal aspect also, whether because of 64.3, 3 arbitrators are required to be appointed. You should have and what has happened in other cases also, because we are not following either 64(3) or 64(3)A1 or 64(3)A2.
My lord,
we are not following, because that cannot be followed.
I got the point, my lord. Yes,
all right.
I am considering on that
point.
Yes.
So you please come and tell me on Wednesday whether there is any. So there should not be any confusion.
Yes.
All right.
Yes.
So it will come on next Wednesday.
Yes.
Yes.
Very well, my lords. Very well.
Yes.
Very well.
Wednesday, so as to enable Mr. Padhi to seek further instructions.
My lords, the appearance memo of Mr. Gaurav Khanna may be taken in record.
My lords.
Item 6.
Item 6, your lordship. Last order, your lordship to supposed to appoint third arbitrator out of list.
Yes,
your lordship.
Let it come on Wednesday. Please be here with me.
Yes, your lordship. Please.
I forgot. I am not.
Yes, your lordship.
Absolutely. So I have to balance 2 things. 1, the convenience of the parties, and 2, convenience of the arbitrator also, and 3, This time I must have the consent of the arbitrator, otherwise unnecessarily.
Yes.
I can understand. And there's another list of arbitrators. Let me see. Next one.
Yes.
I just forgot.
Yes. No.
Item 7.
Item 7, your lordships, as per your lordships direction, the substitution petition has already been filed along with the fresh Bhinama, your lordships.
Along with what?
A fresh Bhinama, your lordships. The legal, on behalf of the legal representative, fresh Vakalatnama, your lordship.
Wakalat.
Your lordship.
What do you call Vanama?
In short, beg pardon, your beg pardon.
Oh, Vinama. Yes.
Your lordship, I am for the opposite party, your lordship.
So what is the, briefly say, what is the matter about?
It's a dispute between the Niladri Security Service is a legal person, your lordships, represented by the proprietor. He has died in the meantime. So the legal representative has to be substituted. Your lordships have directed me to file the substitution petition. Today that has been filed along with the Bhinama of that legal representative. Right.
But that is not there on record. Is that there?
Because today it has been filed.
By London Council appearing on behalf of the London Council, Mr. So-and-so, that an application for substitution has been filed today, consequent upon the death of the petitioner. Must uplist this matter on next Wednesday along with the said substitution application. Yes.
Hello, guys.
Item 8.
Obligators.
Item 8, on the last occasion, my Lord Senior has filed a counter affidavit. I have to file a rejoinder. On the last occasion, I have taken time. Further 1 week time may be given.
1 week further time is allowed for the petitioner to file rejoinder through the objection petition. Filed on behalf of the respondents or opposite party. What do you call it?
My Lord, the respondents.
So yes.
Item 9.
Item 9, my land friend suggested 3 names. Second name is page 50. Prakash Ranjan Barik is a small case. Advocate Prakash Ranjan Barik may be appointed. They have given 3 names, out of which Prakash Ranjan Barik name is there or Santanu Soding there. Any name? Prakash Barik name.
Yes.
Item 10.
Last item,
I pass on the slips, my lord, accordingly. I may be taken along with me, counsel, sir.
Took time to file objection to my arbitration. Not filed today because allow me more time for filing objection.
Why are you opposing?
The opposite party.
1 week for the time. Therefore, opposing means
no. To appointment of arbitrator. Are you opposing, my lord?
Are you opposing his request for appointment of arbitrator? Why? All right. 1 week further time is allowed for the opposite party or respondent? Opposite party. Filed. Yes. Objection.
Item 11.
11, my lord.
Objection. Yes.
11, we have discussed and Honorable Justice Dr. A.K. Rath, my lord, to be appointed as arbitrator. I've discussed with my friend. He has also agreed, my lord.
A.K. Rath.
Item 12.
Item 12, I'm filing a rejoinder. This is now the other side counsel. What should I call it? On 13th, if
As jointly requested, does this matter on 13th?
I'm sorry, on the last occasion, I was in the virtual mode, so could not place my case properly. I beg apology for that.
That a rejoinder has been filed to the objection filed on behalf of the opposite parties, a copy of which has been served upon learned counsel for the opposite party today itself. Yes.
Item 13.
13 also, we have agreed to the appointment of Justice Dr. A.K. Rath, my lord. Justice Dr. A.K. Rath, my lord, we have agreed to that.
Page 60 is the arbitration clause.
Yes.
When you may be the arbitration center. Oblige.
Item 14.
That's why I am appearing today. This is my fresh Vakalatnama.
Why first Vakalatnama?
Last order kindly.
Yes. So will that change the law? Vakalatnama, whether that will change the law? Huh?
Oh my God.
Somebody was appearing after receiving the notice, we have appeared.
No, if there is no arbitration clause, then where is the question of appointment of
My
arbitration?
lordship, my just humble request is, there is the arbitration, and arbitration is a part and parcel of the amicable settlement.
No, it is not. The present application has been filed seeking appointment of filed under section 11 of the Arbitration and Conciliation Act for appointment of an arbitrator. Stop. And senior counsel appearing on behalf of the
Opposite parties.
petitioner, on behalf of the opposite party, is correct in his submission that there is no stipulation for resolution of dispute through the process of arbitration under the general conditions of contract in question. Stop. Accordingly, this application has no merit and is accordingly dismissed.
My lordship, liberty may be granted.
We have our own limitation, Mr. Counsel, in such proceeding. Beyond appointment of an arbitrator, we don't have any power.
My lordship,
Item 15.
Item 15, my lord, I am praying for adjournment on the ground that your lordship, I have supposed to file an additional affidavit regarding communication of board export, my lord. So, my lord,
Communication of?
one letter to the my lord, dispute review expert before going to arbitration and pre-stage, pre-procedure.
All right. As requested on behalf of the petitioner, list this matter on when? Next week?
Next sitting.
Next week.
Yes.
Item 16.
Same problem.
No, ma'am. Here, the arbitration clause is here.
Please take a look. Where is that? Where is the arbitration clause? Yes.
I have no objection, Your Lordship. Page 34 is the arbitration clause.
No objection.
I have no objection. Annexure 1, page 34.
Senior advocate Durga Prasad Nanda may be appointed.
Durga Prasad?
Nanda, DP.
Very well.
What is the amount? What is the dispute? What is the amount of dispute? All right. Yes.
Item 17.
Item 17, my lord, I have just received a counter affidavit today morning. My lord, if
It
sometime.
is stated by the counsel for the petitioner that he has received a copy of the counter affidavit filed on behalf of the opposite party. Today itself, shortlist this matter on when?
1 week after, my lord, at any time, at your lordship.
2 weeks.
Grateful.
Item 18.
And item. My lord, I am appearing today for the respondent, opposite party number 1 and 2, both, my lord. Item number 18, 19, and 20. 3 cases I will today, my lord, and pray for which time to
Why?
highly counter.
Counter.
My lord.
As requested on behalf of the opposite party, list this matter on 4 weeks so as to enable him to file counter affidavit, comma if required. Full stop. Yes. Item
18,
number
19,
18, 19,
18, 19, 20.
20. All right.
18 and both 1 and 2. Opposite.
18, 19, and 20.
My lord.
20. Yeah.
It's the list. Item number 1, BLAPL 1367 of 2024.
May I please, Your Lords?
Yeah, who is appearing for the state?
Yes, my lord.
Yes, sir.
I am for the state.
Mr. Samantra was appearing, no?
Today he is not there, my lord.
Today he is not there. So did you see the case ID?
Yes, yes. In this case, I see other cases revisions are there, but we have only the petition copy, my lord. Now, no judgment, no deposition copy, nothing is there.
I know you are appearing in bail application or what?
Bail, one case is bail.
That first one.
First one is 1, 2, 3 are bail. Other are criminal revisions.
Well, at item number 1, 2, 3, 3 are arising out of same case. 1 case arising out of same PS. 3 accused persons, 1.
Have you seen?
Yes, yes.
The
I have
case ID?
gone through
What
that.
is there against them?
The 3 persons are traveling in a bus, my lord. 1 and 2 are husband and wife. Another is from petition number 2, item number 2, Barun Banerjee, 49 kg and 900 grams of ganja was seized.
From his possession?
Yes, my lord. Conscious possession. And 3 were traveling in that bus. And
So why did you leave others?
now others are there, my lord. The item number 1 which is Luki Banerjee, who is that
No, how many persons were traveling in the bus?
3. There are many persons are there. The 3 are traveling in conjointly, my lord.
Conjointly.
Yes.
And what about others? They were not associated.
No, they are not related to these persons, my lord. Barun
Did you
Banerjee.
Did you verify that all the passengers who were traveling in the bus, whether they were associated with petitioner number 2?
The FR story is that, my lord.
So is there any material
Yes.
beyond the fact that this Arun Banerjee had disclosed about involvement of these 2 ladies? This is your case, Mr. Counsel.
Yes, ma'am. My lord, police went to the inside the bus and found bags kept in the sleeper coach of the Barun Banerjee. In the seat of the Barun Banerjee. They were 2 ladies, they were sitting in another seat number 19 and 20, other seats, other travelers are there. He, on being asked, he disclosed that, yes, I was transporting and those 2 persons are also along with me. One lady is from outside state, another is his wife. They are sitting in other seat number different, along with other passenger. So that is the only disclosure step. Thereafter, other matter if there.
So the application of Barun Banerjee can be rejected and they can be allowed. Is this permission?
My lord.
Yes.
Yes.
Since when you are in custody?
Well, I'm in custody since in custody 8/11/2023, my lord. About 1 year.
And
All are, my lord.
And what is the quantity
49 kg.
49 kg, 900 grams
of
ganja.
it is the prosecution's case that the police party raided a bus. Which place?
My
Which
lord,
place?
bus at
Raja Bosa Chak.
yes, Raja was
Bisoi. At Bisoi.
at Bisoi,
Which
is traveling to Kolkata.
Transport. What is that?
The bus is traveling to Kolkata.
Kolkata.
In the midway, it was intercepted.
Yes, yes, at the Bisoi halt.
Bus was intercepted. That bus was intercepted by a police party on 8/11/2023, in which these petitioners were traveling. So from the possession of the petitioner Barun Banerjee of BLAPL 1368 of 2023, 49.500 gram of ganja was recovered. So was allegedly recovered. He is said to have disclosed to police that the petitioner Luki Banerjee, bracketed BLAPL number 136724, was his wife, and
Ram Sakhi Devi.
petitioner Ram Sakhi Devi, bracketed BLAPL 5386 of 2024, were also traveling with him. So stop. Next, London Council, appearing on behalf of the petitioners, has argued that over and above the allegation that the petitioner Barun Banerjee, that the accused Barun Banerjee disclosed the names of two petitioners, namely Luki Banerjee and Ram Sakhi Devi, that they were also traveling with him, there is absolutely no material against him justifying their implication. So stop. He has argued that the petitioners have remained in custody since 8/11, continuously since 8/11/2023, and there is no chance of
Charge sheet has been submitted.
And there has been no progress at the trial. So stop. Next, considering the circumstance, he has also argued that in the absence of any allegation that the said ganja, any material that the said contraband was recovered from possession of the petitioner Luki Banerjee and Ram Sakhi Devi, the embargo under section 37 of the NDPS Act shall not apply as against them. Stop. Next. Learn public prosecutor.
Additional standing counsel.
Learn standing counsel.
Additional standing counsel.
And standing counsel representing The state, on the other hand, has submitted that the contraband was recovered from conscious possession of the petitioner Barun Banerjee, who was traveling along with two other petitioners who have been named in the FIR. First off, he submits that it appears from the prosecution's case that all the three were jointly carrying the contraband, and therefore they don't deserve the privilege of grant of regular bail. Stop. Next, after having heard learned counsel appearing on behalf of the petitioners and learned standing counsel, additional standing counsel, I find that there does not appear to be any material against petitioner Luki Banerjee and Ram Sakhi Devi disclosing their possession over the contraband, disclosing their knowledge about the possession of the said contraband with the accused Barun Banerjee, except a disclosure made by the said accused Barun Banerjee. So stop. Since the petitioners, accordingly, the application on behalf of the petitioners Luki Banerjee and Ram Sakhi Devi are allowed. Stop. Let them be released on bail. Stop. Next. As regards Barun Banerjee, I am of the view that since the contraband was recovered from his conscious possession, conscious possession, he should not be granted bail at this juncture. His application BLAPL 1368 of 2024 is accordingly dismissed. Or पहले लिख देना 1367 of 2024, 5386 of 2024 allowed. First paragraph, this application has been filed for so and so.
A condition, local security. There are outsiders. Local security.
That the court below will consider.
Yes.
Yes.
For hearing item 4.
May it please, Your Lordship. Your Lordship, the present petitioner has been convicted under section 409 IPC, Your Lordship.
Yes, ma'am. Last time an argument was being made that it is not an interest. No. So someone else was making.
That was probably in my case.
Oh, no. All right. Please make your submissions. So what is the conviction 409?
409.
And what is the sentence?
Your Lordship, the sentence is for 2 years. The sentence is for 2 years, Your Lordship.
2 years.
Yes, Your Lordship. No, accordingly, he's sentenced to undergo 1 year, Your Lordship. So,
1 year.
yes, sir.
And
1 year and a fine of 2,000.
and do you have any idea the period of custody? No idea.
No, Your Lordship, the period of custody is the man is
Yes.
apparently very old, Your Lordship. Your Lordship, the present petitioner was working as a shop assistant. While he was working as a shop assistant in Tribal Development Corporation, Odisha Limited, Jaipur, Your Lordship. In the year from 1991, Your Lordship, he was posted there from 10/4/1991 to 16/9/1991, Your Lordship.
16/1?
16/9/1991. In the period of his service, Your Lordship, he was entrusted with an amount of rupees 7,16,000, Your Lordship,
Yes.
to purchase maua flowers, Your Lordship. To purchase the maua flowers on behalf of the government, Your Lordship, from the local vendors, Your Lordship. So the allegation against me is that while I had been entrusted with this much of amount, I have committed, an audit was conducted, an internal audit was conducted. PW3 has conducted an internal audit and find out that there is a shortage of 3,19,622. So I have been alleged of criminal misappropriation of 3,19,622. So the learned SDGM has also convicted me. The learned session judge has also upheld the appeal. I have come before your lordships in this revision, and I heavily rely on PW3 and PW4, your lordship. So basic allegation against me is, although I have procured the maua flowers, your lordship, but I have not procured it at the price which had been set by the government, your lordship. And some maua flowers, although I have procured, but I have not reflected the same in the stock register, your lordship. So that is why, although they have not physically verified the stock, only on the basis of the cash book, your lordship, without doing any physical verification, they're saying that since I've not reflected that in the cash book, that is why I'm liable to be convicted of criminal breach of trust, your lordship. May I take your lordships to PW3, your lordship? That is the internal auditor, your lordship. Page 102, your lordship.
Page 102 of
A paper book.
paper book.
Paper book.
Oh, fine.
Paper book.
So you don't have.
No, your lordship. I mean, of the brief, it has been marked, your lordship. However, it is PW3, your lordship. The name is Lingarat Sahu.
P102.
Your lordship, here it is page mark. Maybe it is differently. PW3, your lordship.
No, page number. What is your page number?
That is.
LCR, yes. I'm seeing the LCR. 83. Yes.
Yes, your lordship. On 30/5/1992, I was entrusted to take up the special audit of the maua flowers account in respect of Jaipur branch of Tribal Development Cooperative Corporation of Odisha Limited, relating to the period of the accused D.N. Das, that is from 1991 to 1992. Accordingly, I started the audit during June 1992 and completed it on 10/7/1992. During the course of audit, I verified and examined the cash book marked as Exhibit 3, stock book marked as Exhibit 4, both the year 1991-1992 of Kalimela Procurement Center. One receipt book for the year 1991-1992 of the same said center marked as Exhibit 5, and invoice book of the same year of the said center marked as Exhibit 6. My special audit continued for 2 months. I am acquainted with the handwriting of the accused, though your lordship, he had no chance to do so. The cash book of Exhibit 3 was being maintained by the accused in his own handwriting. Stock register as Exhibit 4 was also maintained by the accused. Receipt book Exhibit 5 was maintained by him, and in this own handwriting, he had issued the receipts to his branch manager Jaipur on different dates in token of payment of cash. Invoice book Exhibit 6 was maintained by him and in his own handwriting, and he had issued invoices from 56/1626 to 1628 and 56/1632. Original of the invoice receipts were issued by the accused are available in the office of the branch manager, TDCC Jaipur branch. During course of audit, it was ascertained that accused was the shop assistant of the Kadimilla Procurement Center from 25/1/1888 to 12/10/91. He was entrusted to purchase mahua flowers direct from the local people at rupees 300 per quintal. For the purpose, he had been advanced with an amount of rupees 7,16,500 from TTCC Jaipur branch. In this period of time from 10/4/1991 to 16/9/1991, the detail of which is mentioned in my audit report. All the aforesaid amounts were recovered by the accused under the following receipts. Para 5. On 16/9/1991, an amount of 1,000 was given to the accused under hand receipt, and that receipt is kept in the relevant file of Jaipur branch. Out of the amount entrusted, accused has shown purchase of mahua flowers amounting to rupees 6,99,600, Your Lordship. While purchase memo number so and so, Your Lordship. Your Lordship, this is pertinent because I have already shown a purchase of 6,99,000. Out of the 7 lakhs that has been entrusted to me, I have already shown a purchase of mahua flowers of 6,99,600.
See, the allegation against you is not of misappropriation of money, rather misappropriation of mahua flowers
Yes, Your
which you
Lordship.
had purchased.
Yes, Your Lordship. So my contention here is that, Your Lordship, since they did not do a physical verification of the same, so what I have done here is I have shown that purchase, Your Lordship, of 6,99,000, Your Lordship, and some amount I have kept it as under the headings of like transportation charges and everything.
No, amount is not the problem. The problem is the mahua flowers which you had purchased.
Your Lordship, that is what is my contention, that they never did that verification that whether those flowers were present in the stock or not.
So this is what he is saying.
Yes.
He has delivered so and so kilograms. How much mahua had you purchased?
Your Lordship,
I'll have to write.
2,332 quintal.
That is the question.
Yes.
It's not the quantity of mahua which you had, mahua flowers which you had purchased was not found. So the only this much you had delivered.
Yes.
1,1289. So this much only you had delivered. What happened to the rest? That is the allegation against you, not